good afternoon, everyone, and welcome to the Brexit Institute of Dublin City University. My name is Federico Fabbrini. I am a professor of law at DCU and the founding director of the Brexit Institute, and it's my great pleasure to open this conference on the Trade and Cooperation Agreement. I'm also extremely grateful to my colleague and friend, Professor Derek Hent, the Dean of the Faculty of Humanities and Social Sciences, for agreeing to chair this opening panel, and I will promptly give him the floor. But allow me to take just a second to emphasize that this is the fifth annual book conference organized by the Brexit Institute since its establishment in 2017. So we managed to keep a good pace of almost one book conference per year, perhaps with the only exception of last year when I was on sabbatical at Princeton. Moreover, I also want to take the opportunity to announce that the proceedings of this conference will be published next spring, in spring 2024, in a book that I am editing for Oxford University Press, which will be volume 5 of the Law and Politics of Brexit book series. So allow me to warmly thank all the contributors for sending in their chapters, agreeing to participate to this project, and of course, revising their contributions after this conference. Moreover, I also want to acknowledge that David McAllister, the chairman of the European Parliament Foreign Affairs Committee, has kindly agreed to write a preface to the volume, which I think will further increase its visibility in the policymaking world. In fact, I think it's worth underlining that this conference on the TCA comes at a very timely moment. As people will know, the Trade and Cooperation Agreement is the international treaty that regulates cooperation between the EU and the UK post-Brexit, both on trade and other economic and non-economic areas. The treaty is very long and very complex, but it has already raised a number of issues, and there are calls to revise it, especially in view of the next UK general election, as well as a rendezvous moment which is scheduled to take place in 2026. So I think we are really fortunate to have an international group of stellar legal scholars, economic historians, political scientists, and trade experts that are coming to DCU today to discuss the treaty. And I think this contributes to strengthen the role of our institution as a place of learning and a hub for thought leadership on Brexit and European affairs generally. So without further ado, I'll hand over to the Dean, who I thank again, and I want to thank you all for participating in this conference.
Okay, thank you, Federico. And it's a real honor to have been asked to chair this session. From an Irish perspective, of course, Brexit is something that we sort of have to deal with on so many levels. And I have to sort of acknowledge the Brexit Institute's work in working through all those levels, from political to economic, the theoretical kind of aspects around Brexit and its real life implications. And I think it's fascinating in terms of bringing together different voices and different perspectives in order to try and understand this thing and how it develops in real time. And so I think Federico and his colleagues need to be commended for that. But anyway, we're here to talk about the Trade and Cooperation Agreement, and there are a number of sessions today. And the first panel is dealing with the context and challenges. So we have 3 speakers, Harold James and Daniela Schwarzer and Billy Mello Arul. And they will have 15 or so minutes each. And after they have delivered their papers, we are open up to Q&A. So we'll have the papers first, and then we'll have plenty of opportunity for questions and answers from those participating. So the first speaker is Professor Harold James. He is Professor of History and International Affairs at the Woodrow Wilson School and an associate at the Bendheim Center for Finance at Princeton University. He is the official historian of the International Monetary Fund. And in 2004, he was awarded the Helmut Schmidt Prize for Economic History, and in 2005, the Ludwig Erhard Prize for writing about economics. Today, he's going to talk about the world's economy, rising inflation, and deglobalization.
Well, thank you very much, Derek. Thank you, Federico. It's a great pleasure to be with you. I'm delighted to offer some preliminary reflections in what you will see is a rather broad brush picture of how the problems lie. I think when you're thinking about the background of the Trade and Cooperation Agreement, you need to think about the discussion of where globalization is going today. The events of 2016, and they're in some senses connected, the June vote on the UK referendum and the November presidential elections in the United States are usually interpreted as a pushback of against globalization, a beginning of a new process of deglobalization. And deglobalization has become something of a buzzword since particularly 2020, and really even more intensively since February the 24th, 2022. But I don't think deglobalization quite captures what is really going on. And it seems to me that there are three aspects of what is shaping up to be rather a new kind of globalization rather than a process of deglobalization. And maybe the Trade and Cooperation Agreement fits into this kind of concept. First is that there's a movement towards forming trade blocs, something in a way reminiscent of the interwar period, but not quite, because there are lots of intermediary countries. And I was just in Vietnam a few days ago. Vietnam is trading much more with the United States now, but also importing much more from China, so that Vietnam is inserting itself as an intermediary in a big supply chain. Secondly, apart from bloc formation, there's a shift towards large-scale public investments and more in the way of government subsidies in order to direct new technologies. I think you can think of a new industrial policy as a way of characterizing it, and probably the best example of it is the United States Inflation Reduction Act. Thirdly, we're in the middle of a really profound technological transformation in which AI, new advances in medicine are driving a very different kind of trade system in which we're really thinking much more about trade in services than trade in traditional goods. In dealing with these challenges, the UK and the US really at the forefront of what we thought was the deglobalization movement of 2016 are, it seems to me, having very different fortunes. That the United States looks economically at the moment very resilient, whereas the UK is the subject of increasing concern, in part due to very long-term factors, low productivity growth, but also to do with the way in which the UK has responded to the post-2016 environment. So there's a large difference, I think, between how the UK and the US responds, and maybe that would be enough. That's the theme of one big part of my presentation, is to say that this is a large difference, that large explains it, in that the United States is a very large country and sets rules. The UK is not a large country and cannot set rules. And so the idea that the UK is going to remake something after 2016, which was one of the beliefs associated with one of the wings of the Brexit movement looks more and more fallacious. So in the paper, I think about the rather divided character of the UK discussion. Is Brexit really an anti-globalization movement? There were substantial anti-migration parts of the EU, but in order to realize all the technical opportunities, there's also a growing recognition that some sorts of migration are really more and more needed. Was it a reaction against trade policy? To some people it was, and some of the voters were reacting, and there's a lot of political science literature on this, to the globalization shock or the China shock after the WTO accession in 2001. But there's also the belief that the UK could act as a pioneer of a new kind of opening up and get rid of the protectionist legacy of the EU. So again, like the migration issue, the trade issue is really full of divisiveness. And finally, the idea of taking back control, which is really at the political heart of this discussion of sovereignty, I think looks different from the perspective of a large country than it does from the perspective of a medium-sized country. So I follow that line of argument in the paper and think of the drivers of the UK's divergence from the rest of the EU. And I group that divergence under three headings. One is a question of politics. The second is a question of the economics of distribution and redistribution. And the third is on a very deep and long scale psychological level. And I want to end with that kind of perspective. But first of all, the political perspective. That the large part of the dynamic of European integration since the 1950s was driven by the question of how to deal with the aftermath of the Second World War, and in particular, how to deal with the aftermath of the fact that in almost all of Europe, national elites betrayed the nation, and a profound political reconstruction was needed. So there were defeats, Germany, France, Italy, everywhere else really, except for Sweden and Switzerland. There was defeat and occupation, and a national elite was betrayed. The most powerful explanation of this development, I think, was offered in the 1960s by General de Gaulle. And General de Gaulle frequently talked about the need to heal the wound in French society created by the defeat of 1940. And then he talked about that in almost mystical terminology, that the wound could only be healed by the weapon that caused the wound. So it's only Franco-German rapprochement that can deal with this wound. Now, this doesn't exist as an issue for Switzerland, Sweden, Ireland. It doesn't exist for the UK either. And so the UK is really almost by definition outside this. There wasn't the sense that the national elite betrayed the country in 1940. On the contrary, this was the heroic moment of the UK in the 20th century. So the UK looks divergent in terms of that particular story. Secondly, the trade question, trade and economic adjustment, that the heart of the European integration project is often described by historians. The beautiful phrase that Alan Millward had was the European rescue of the nation state. What's it rescuing? It's rescuing a particular type of distribution. And the challenge that the European countries faced in the middle of the 20th century was a challenge of globalization, that globalization made the big agricultural sectors very vulnerable. And in order to ease both the economics and the politics of the transition, agriculture needed to be protected within the European framework. The European framework offered a better way of dealing with this kind of protection than the national framework did. So France, Germany, Italy, they all have very, very large agricultural sectors, and farmers played a critical role in the story of the destabilization of democracy in the interwar period. But that's not the case for the UK. The UK had really managed its agricultural sector and the decline of agriculture in the 19th century. So agriculture and agricultural protection don't play a very, very big role in politics. And there's always going to be that divergence between the UK perspective and the perspective of the rest of the community or the union. But thirdly, the long-term psychology that I think is really at the heart of the assertion of taking back control, or the idea of a rediscovery of the principle of sovereignty. It goes really back to centuries ago. So it's not even a story of globalization or of the 20th century or of the reaction to the Second World War. It's a story of the way in which the UK institutions were fundamentally shaped by what took place in England in the 1530s. And the critical document there, and it's a legal volume, so Federico encouraged us to cite statutes, is the Act of Appeals in 1533, and the very famous preamble to the Act of Appeals, that this realm of England is an empire. And the fundamental point of that was that it was a prohibition on appealing out of English courts to any other kind of jurisdiction. So it was an assertion of legal sovereignty, and obviously done in the particular context of the way in which the king's divorce was appealed to the papal court in Rome. And the Roman court was at that moment under the thumb of the nephew of the divorced Queen of England, or would-be divorced Queen of England, Catherine of Aragon, Emperor Charles V, whose troops were occupying Rome after 1527. So this is a long-term presence, and I think, if you excuse me briefly, one of the best ways of amplifying this discussion is in terms of a linguistic distinction that was already made in the 16th century of using prepositions, that England was of the rest of the world, but not in it. Shakespeare puts that very beautifully in his late drama Cymbeline, when the heroine of Cymbeline, the Princess Imogen, says that in the world's pool, our Britain is as of it, but not in it, in a great pool, a swan's nest. And that semi-detached characteristic, I think, is the story of Henry VIII and what Henry VIII does. A revolution in government, famously discussed in the middle of the 20th century by English constitutional historians, but also a revolution in foreign policy, and that the idea of the foreign policy after the Reformation was continually balancing at that time between France and Spain. And so the idea is that you don't participate in this, but you stand offshore as a balancer. And that, I think, is the strategy that is at the psychological heart of the discussion today, but seems to me to be a poor or inadequate response, since we're dealing with the rise, if we're thinking of the big globalization story, the rise of a new imperial power with imperial ambitions, China, the death throes of an old imperial power, Russia, and the British proposal is to deal with this, as it were, by the methods of Henry VIII, the balancing methods, the playing off coalitions, and the mechanism, the thought process, and sometimes also the petulance of this kind of approach reproduces the England of the Reformation and of Henry VIII. Thank you.
Thank you, Harold. That was a brilliant whistle-stop tour of context in terms of the Brexit, the Brexit, I suppose, action. Coming from Ireland, of course, I think the linguistic thing is kind of interesting. The kind of words or language used, the idea of being of the world but not in it, I think is quite brilliant. But listen, we can come back to these questions and answers when we've heard the other speakers. So thank you for Harold. Our next speaker is Dr. Billy Melo Aruo. His research interests focus in the areas of international trade law and EU external trade relations. His monograph, The EU Deep Trade Agenda, Law and Policy, was published by Oxford University Press in 2016 and was the first comprehensive legal examination of regulatory disciplines included in EU trade agreements. He has also published multiple articles in leading peer-reviewed law journals on issues such as trade and services, trade and sustainable development, and the democratic legitimacy of trade agreements. And today, Billy is going to talk to us around the Windsor Framework, Northern Ireland, and the rebuilding of EU-UK trust.
Thank you very much. First hurdle, I'm going to have to share my screen because I do have slides. Hopefully everything goes well. Let me know if you have it.
Yes, that's good.
Perfect. Right, so I'm going to talk a bit about the Windsor Framework today, but obviously I won't have time to give you a full, detailed, comprehensive account of all the technical aspects of the reform. And instead, what I'll try to do is give you an overview of the Windsor Framework, and more specifically to contextualize these reforms in light of the past contestation of the protocol, to understand whether the Windsor Framework addresses some of the criticisms that are leveled at the protocol, how it does so, and whether this approach actually is conducive to the establishment of a viable and stable Northern Ireland's post-Brexit regime. So I'm going to start off with a few, well, really with my conclusion. So there's a bit of a spoiler alert here. The paper really makes three very basic observations, and the first one is it's quite an original. It's actually made by Federico in his own introduction, which is that the Windsor Framework, despite all the fanfare surrounding it, doesn't really radically transform the regime that is established by the protocol. In fact, as we'll see in a few slides' time, there are really very few areas where the text of the protocol itself has been amended, and most of the main features which underpin the operation and the functioning of the protocol, like, for example, the application of EU law in Northern Ireland and the continued jurisdiction of the European Court of Justice, all of those features remain very much in place. So instead, what the Windsor Framework does is try and reform the operation of the protocol by continuing what was a pre-existing practice, so pre-existing to the Windsor Framework, which is to address some of these criticisms leveled at the protocol by progressively eroding and softening some of the commitments, obligations that were included in the original protocol. And whilst that is an efficient way of addressing some of these criticisms, there are problems, there are challenges associated with this approach, which is that, first of all, it only partially solves some of these problems, and more problematic, it actually creates new issues, new challenges. So before we get to the Windsor Framework, I thought it might be useful to just look at how the protocol was contested in the past 3 or 4 years. So in my paper, I draw a distinction between 3 very broad categories of criticisms that are leveled at the protocol. And I stress the term broad here because there is an element of overgeneralization. And in fact, many of these criticisms overlap and interact with each other. But broadly speaking, you have, first of all, the trade-related concerns, which are really about the Irish sea border, about these increased checks on goods that are coming from GB and are being moved into Northern Ireland. And then you have, to a lesser extent, the criticisms of the state aid regime and the VAT regimes established in the protocol. And then next to that, you have what I refer to as the sovereignty type concerns, which really tie into this very particular conceptualization of national sovereignty, which was put forward by the Leave campaign and was really embraced by the UK government post-referendum, which is this idea that national sovereignty means being able to regulate domestically with and being completely unconstrained from international disciplines. It also means not being subject to an international court, especially a supranational court like the ECJ. And then the third strand of criticisms is what I label the governance or democratic legitimacy criticisms, which really boil down to the fact that Northern Ireland authorities and actors, stakeholders have very little input, influence in the decision-making processes that lead to the application of EU law in Northern Ireland. Also quite useful to look at how the EU and UK respectively proposed solving these issues in the past few years. So for example, for the trade-related concerns, the EU's approach was spelled out in a series of non-papers which were published, I think it was October 2021. I might be wrong. I'll have to double check that, but I think it was around about the latter end of 2021. And the approach was really to just reduce some of the customs and regulatory compliance checks on GB goods moved into Northern Ireland, as long as the UK agreed to implement certain safeguard mechanisms, for example, like labeling requirements and increased monitoring requirements and reporting requirements. By contrast, the UK's approach was very different, right? And it was really embodied by the Northern Ireland Protocol Bill. And you'll remember, if you remember the bill, at the heart of it was this concept of excluded provisions, excluded clauses, where the UK government could essentially decide to disapply whole segments of the protocol and replace them with a new regime. And really, it focused very much on the trade-related dimension of the protocol. Now, with respect to the ideological sovereignty-type concerns, the EU's approach, well, I put a picture of tumbleweed in the desert because really this is an area where the EU simply refused to engage in any discussions, right? It was the role of the European Court of Justice in the application and interpretation of EU law was non-negotiable. The UK, and we saw this in the UK command paper, the UK was very keen to replace the jurisdiction of the ECJ with a state-to-state dispute settlement mechanism akin to the one that we have in the withdrawal agreement. With respect to governance issues, this is where there was more commonality. There was a common approach between the two parties, in that there was an agreement that there was scope for an increased engagement with Northern Ireland actors and stakeholders. Right. So how does the Windsor Framework address these criticisms? So there's a lot in the Windsor Framework, but I want you to just take away 3 points here. The first one, and hopefully the slides shows this, it should be fairly evident, is that when it comes to sovereignty type concerns, those are not addressed in the Windsor Framework. So you'll recall that in the lead up to the announcement of the conclusion of the Windsor Framework, there were a lot of reports in UK media that there was going to be a significant change in terms of the dispute settlement provisions mechanism in the protocol. And in particular, that the role of DCJ might be substantially changed or even scrapped. That hasn't happened at all. So the role of DCJ remains very much the same as it was in the original protocol. The second point is to notice that how many changes of the Windsor Framework actually require amendments to the protocol. So there are 2. There are the changes to the VAT regime, which essentially boils down to removing some of the EU VAT rules that are listed in the annexes to the protocol. So to give Northern Ireland a bit more flexibility or autonomy in its taxation policies. And then secondly, you have the very important storm and break, right, which is really about governance, about democratic legitimacy. And this is the mechanism whereby Northern Ireland Assembly can, subject to some fairly stringent procedural and substantive requirements, it can request the UK government to object to the application of EU law that is being amended. So these are EU laws that are already listed in the annexes to the protocol that are being amended or they're being replaced. But beyond that, all the other reforms occur either by exploring the interpretive flexibility within the protocol itself. So, for example, one of the things that the Windsor Framework reforms do is that they expand the concept of what constitutes a good not at risk of being moved on to Northern Ireland. But that's done by a joint council decision, which provides new criteria for the determination of what constitutes a good at risk of being moved on to the EU. And then the rest is all through EU law amendments, right? So, for example, the reforms on which allow for retail agri-food goods from GB to move into Northern Ireland without being subject to the full panoply, full list of EU laws listed in the annex. That's done by EU regulation. Again, with respect to trade and medicinal products, also they can now be lawfully, UK manufactured drugs can now be lawfully placed in Northern Ireland with an authorization from the relevant UK authority. All of that is achieved by EU regulation. And next to that, you have the Westminster break, which is done by UK legislation, right? And this is the mechanism where Northern Ireland Assembly, again, can request the UK government not to apply new EU legislation. So EU legislation which would fall under the scope of the protocol according to the EU, but is not currently listed there. And then the reforms on enhanced engagement and stakeholder, that's really done through declarations, unilateral declarations from the EU. Right, so broadly speaking, the approach that's followed in the Windsor Framework in terms of reforming the protocol is what I refer to as reform via dilution. And really, it's a practice that's been part and parcel of the operation of the protocol since its inception, right? And it's essentially turning a blind eye to the commitments that were made in the original protocol, ignoring some of them because the consequences of fully applying the protocol are too problematic. And that was reflected, for example, in the grace periods, right? So the grace periods, which were agreed before the protocol was even made operational, the grace period essentially amounted to an agreement between the EU and the UK not to fully apply the obligations derived from the protocol, because otherwise that would mean very problematic checks on key goods that were being moved from GB into Northern Ireland. And to a large extent, and this applies specifically to the trade-related reforms, the Windsor Framework formalizes the grace periods. And by placing these grace periods on a legal footing, the advantage for the EU, of course, is that it can add, it can add conditions. So the EU agrees to suspend or not apply some of the EU law that would normally be applied to third countries. But in exchange for that, the UK has to agree to apply a quite considerable list of safeguard mechanisms, and it has to do so on a continuous basis. So these include labeling requirements, monitoring requirements, in some cases, even compliance with minimum standards under EU law. So the story of Windsor Framework is really a story of trade-offs. There is a trade-off, for example, between the reduction of the burden that's placed on businesses involved in GB Northern Ireland trade. A lot of that burden now is about shifted to the UK government in terms of a requirement to implement safeguard mechanisms. And because all of these concessions are granted unilaterally by the European Union, it means that these reforms are actually extremely fragile, because to a large extent, the success of the Windsor Framework will depend on the UK's ability to continuously convince the EU that it has put in place these safeguard mechanisms, and that these safeguard mechanisms are adequately protecting the integrity of the internal market. It's also a trade-off between borders. One of the consequences of reforming via dilution is that you allow a significant subset of GB goods to lawfully access the Northern Ireland market and be lawfully placed in the Northern Ireland market, even though they don't fully comply with EU laws. So what that means is that now in Northern Ireland, we will have a number of goods that can be lawfully placed in our territory, but which cannot be moved on to the Republic of Ireland. So the price that the parties paid for the softening of the Irish Sea border, for the reduction of these checks at the Irish Sea borders, is the emergence of a regulatory burden in the island of Ireland between North and South. A similar trade-off exists with respect to the governance mechanisms, because now that we have the Stormont break and the Westminster break, if they ever actually become operational, because remember, these mechanisms only actually apply if we have a functioning assembly and executive in Northern Ireland, which, well, we can all dream, but it's not really, it feels like a very remote possibility at this stage. But if it ever comes into play, the reality is that we have a number of mechanisms which increase the chances of regulatory divergence between Northern Ireland and the Republic of Ireland, and so to exacerbate this regulatory burden within the island of Ireland. So just to close up, because I can see I'm running out of time now, to reiterate the point I began with, which is the Windsor Framework is actually quite successful in terms of addressing many of the criticisms that have been leveled at the protocol. And it will certainly make a difference, especially when it comes to reducing both customs and regulatory compliance checks at the Irish Sea border. But it doesn't fully address the problem. Those checks are still very much there. And it creates new ones, not least the regulatory border within the island of Ireland. So by no means is the Windsor Framework the end of the road. This question of the Irish Sea border isn't finished, and we've created a new question. And the Windsor Framework will require constant maintenance and constant renegotiation from both parties. And the question then, when these renegotiations are required, is what do we do? Because it's arguable that reforming via dilution, that's reached its limits. There's only so much you can soften or erode the original protocol commitments without having to reinstate a land border. And so then the answer to that question, of course, is that the issue of Northern Ireland's post-Brexit trade regime has to maybe be addressed in the context of the UK broader trade relationship, which brings us back to the TCA. But I'll leave it there.
Okay, thank you, Billy. Thank you for that. sort of, I suppose, presentation of the Windsor framework in terms of, I suppose, creative ambiguity, in terms of something like that. I'm coming again from an Irish perspective. Endings only mean new beginnings for us. So nothing new there in terms of the Windsor framework. Our third speaker, Daniela Schwarzer, is delayed and having technical difficulties joining us. And hopefully she'll be here within the next 10 minutes or so. But obviously, it allows us an opportunity to begin our questions and answers, or begin this discussion, or start this discussion a little sort of early. So before, I suppose, people start thinking about that, I'd just like to sort of raise or begin thinking about something that sort of Harold raised in terms of that wonderful sort of contextual explanation of the reasons behind Brexit. And that interesting one, that historical one of going back to kind of legal sovereignty. I mean, what's interesting to me is the kind of explanations or the narrative that you had. It was never fully articulated during the debate around Brexit that these obviously very important reasons were never fully articulated, were never given. They were all more immediate, I suppose, in terms of that immediate political kind of argument. But any comment on that, Harold?
Yes, I mean that's absolutely right. I mean, and there's, I think a kind of odd variance between the prominence of those fundamental issues to the minds of many of the people at the core of the decision-making process, and the way in which that's translated in 2016 into an appeal to the electorate. And those sovereignty issues don't really appear very much in the discussions with the electorate, and the trade issues, the migration issues are really at the core of it. You know, I was in the UK in the weeks before the referendum and tried to follow these debates, and I was really struck by the centrality of the migration issue to the discussion, and the way in which this longer term debate about the sovereignty didn't really emerge. But if you think of the the mindset of Boris Johnson in the paper version of this, I have a number of citations to the statements, the kind of fascinating statements of Boris Johnson. That's where they really appear, and because actually it's mediated through Winston Churchill's speeches. Again, in the longer version of it, I think about the Churchill speeches on Europe, which Johnson liked to cite. They go exactly back to there's Tudor prepositions of in and of, that Churchill thinks of Britain as of Europe but not in it, and Boris Johnson cites that with tremendous approval. So it's as it were, linguistically locked into a mindset, but it's not the kind of issue that really galvanizes the voters in the 2016 and the June referendum.
Yeah. No, it's fascinating, and also it's the appeal to a kind of distant history as opposed to the kind of current problems, and the idea that the world has changed because of all the other issues we talked about, and even with Billy, technology and so on.
Right. I mean, just one comment on this. I mean, as a historian, I find it absolutely fascinating that the UK history in schools focused really exclusively on two particular episodes in the long story of European history. One on the Tudor period, and particularly on the Henrician Reformation, and secondly on the interwar period and the Nazi domination of Europe. And those two images, one in which Spain is controlling European fortunes and the other in which Germany is controlling European fortunes, really stood out, I think, to generations of British school children.
Yeah, it is interesting. Federico, you had your hand up there.
Yeah, thanks, Derek. I wanted to follow up on this conversation, which is extremely interesting, but also ask a question to Billy on his very interesting discussion about the Windsor framework. So on this point that Harold and yourself, Derek, was just raising, I think, Harold, you're depicting a wonderful fresco, almost in the Italian style of the Renaissance, about the long history of the UK relationship with the European Union. But in a way, I wanted to ask you sort of the reverse question, which is the UK was still a member state for almost 50 years. I mean, from your perspective, the long-term perspective of an historian, that almost didn't make an impact, right? Is that what you're sort of suggesting in between the lines? So I'd be happy to have your thought on that. For you, Billy, a quick question on the Windsor framework. I think you do an excellent legal analysis of how the text operates, but I wonder whether you are making it sort of more dramatic than it is, its impact on North-South trade in the island of Ireland. It's true that there are some concessions that the framework made for goods which are not really in conformity with EU standards to circulate in Northern Ireland. But in the end, I mean, we're talking about some pharmaceutical products that will be labeled not for circulation in the EU. We're talking about, I guess, chilled meats and maybe some seeds for plants that will be used in Northern Ireland. So this is not really something particularly threatening, at least to my eyes, but maybe I'm wrong. And in any case, I wonder, isn't this ultimately about mutual trust? So if the EU trusted the UK as a democracy based on the rule of law that respects some international standards, will look at these technical issues, then that's more or less fine. And from that point of view, the framework does address probably the biggest hurdle in the bilateral relation.
So should I answer first, or does Billy want?
Sure, Harold. Yeah, you answer first, and then Billy. Yeah.
So I think, Federico, that's a wonderful point indeed. The British membership of the European Community since 1973 was really transformative, and it is part of the explanation of a modernization of the British economy in the late 20th century. But what I think is fascinating in retrospect when we construct this story is how the malaise sets in British politics in the early 90s at the time of the Maastricht Treaty. And it's exactly that movement from the European community as a kind of equivalent of a slightly deeper free trade agreement that the UK was perfectly happy with, and that it was a member of EFTA before it joined the European Economic Community. From the movement of a simple trade agreement, which is compatible with the concept of national sovereignty, to something beyond that. And I think one final push to this was given by the debate that you've been involved in very much, Federico, about deepening the fiscal union in the European Union in the aftermath of the European debt crisis and the global financial crisis. And it was very striking there that David Cameron and George Osborne, particularly George Osborne, kept on asserting the idea that was pushed also very heavily by the United States, that Europe needed to move towards greater fiscal integration. But then Cameron and Osborne added the rider, this is what you need in order to make a monetary union work, but we don't want to be part of it. And Cameron, who obviously is part of the Remain story, is actually also plunging the conceptual knife into the post-1992 conception of the European Union.
Thank you, Harold. Billy?
No, Federico, you're absolutely right. I'm over dramatic. There's an element of drama in my paper. Some would say a bit of a rant, and maybe that's just a consequence of having worked on Brexit and protocol for the past few years. Eventually, it gets to you. But what I would say is that yes, you're right in the sense that it only concerns certain goods. Retail, agri-food goods, fishery products. You also have customs facilitations on all goods that are deemed not at risk of being moved on to the EU. And really, when you look at the trade between GB and Northern Ireland, I mean, it's so small that you could say, well, actually, the EU could take on that, that risk. But what I try to express in my paper is that this is part of a trend. It's a trend that started with the protocol, where we're slowly chipping away at some of these safeguard mechanisms, at some of these requirements that are there to protect the integrity of the internal market. And so the Windsor Framework is in the first episode. It's just the latest installment in an ongoing saga which seeks to whittle down these protections. And added to that is the fact that we need to be aware that these checks, the problem with these checks is not really about the economy, right? For many here in Northern Ireland, the existence of these checks are an affront to their identity, right? To their sense of belonging within the union. And there's an element of that where you ask, well, when will it be enough? Or is it that any check is problematic? And if it turns out that following these reforms, the existence of these checks, the fact that the Irish sea border is still very much present, is still an issue, then what do we do next?
Okay, thank you, Billy. And I think we have a question there from Andrea beyond it. Yeah.
No, I actually, good afternoon. I lowered my hand because it was basically the identical question that Fabbrini asked Billy. So I just, perhaps just an extra comment. I mean, again, also, Professor James mentioned that Brexit is also a psychological issue. And then it's extraordinary that, you talk to the European Commission, the official version, the Windsor Framework has sorted out everything. There's nothing to discuss. So there's no really, I mean, I agree with you that probably would be an endless negotiation, but it's quite extraordinary that the official position is that everything is now sorted. So maybe psychology can help.
Yeah, I mean, they also said that when they concluded the withdrawal agreement and the protocol and the TCA. So Brexit as a way of just keep reliving the same dramas. Again, I do think that the way out of it, because there are bound to be new issues. So if you look at, for example, the Westminster break and the application of CBAM, that's a problem that's right around the corner. The EU has already asked for the CBAM to be incorporated in the protocol, and the UK so far has rejected that idea. Now you add in the Westminster break to the equation, and it's pretty much a nigh-on guarantee that you will not get cross-community support here in Northern Ireland for the inclusion of CBAM. And what do you do then, right? You have to renegotiate it, or you go down the dispute settlement route, which is equally problematic. So I think part of the paper was just, look, we need to be aware that these things are around the corner, and how do we address them? And again, I think the solution is to center the protocol and to center Northern Ireland in the TCA. And of course, a lot of that depends on the political appetite. of both parties, but I'd say especially from the UK side.
Can I just jump?
Sorry, yeah, sorry,
No,
Federico.
Derek, go ahead, absolutely.
No, but it's just like in your title, you're talking about trust, and I suppose like all nation states at a sort of macro level, but then even at the micro level, it's all about trust. And so having endless negotiations is not a problem if you actually trust that people are going to sort of deal, that they're in good faith, and that if decisions are made, that they will be enacted. And then you go on to the next problem and so on and so forth. But that's still the problem, though, isn't it?
Can you hear me?
Yeah.
Well, I hope not. So I hope that the Windsor framework heralds this new era in UK relations, which is based on constructive dialogue and mutual trust, and there is scope for that, of course. But lawyers, we think about the worst case scenario. But yes, as long as you have mutual trust, and obviously this is where perhaps I didn't really touch on this issue extensively in my presentation, but where the increased involvement and engagement of Northern Ireland actors, and not just Northern Ireland authorities, but also stakeholders in the process, is hugely important, because then you can address the problems before they blow up, right? So, for example, with respect to new EU legislation, which the EU thinks falls within the scope of the protocol, you can have that discussion in the context of the specialized committee or the committees focused on trading goods, and address those problems there and find a mutually agreeable solution. So with all the focus on the Stormont breaks and the Westminster break and the red and green lanes, ultimately, hopefully the biggest improvement in the Windsor framework is this enhanced transparency and enhanced engagement with Northern Ireland stakeholders in the process, in the decision-making process.
Okay. Still to be tested, though, I suppose. That's yeah. Federico, yeah.
No, I wanted to follow up, actually. I mean, I had a question very similar to yours, Derek. And I mean, I take this as a conversation more than a Q&A session to some extent. But I suppose, Billy, my question to you is, to what extent do you think the changing political environment moving forward might lead to a smooth resolution of a lot of these issues? So you mentioned the case of CBAM, right? But of course, the House of Lords, in a report it published, I think this summer, has proposed tying the United Kingdom emission trading scheme to the European one. And it makes total sense, right? Because both the EU and the UK are committed, are bound by the Paris Agreement on reducing, on fighting climate change and reducing the rise in temperatures. They both have schemes which are more or less fairly similar. So as long as Johnson was pushing for regulatory divergence, you had all those questions. Is it feasible? How do you manage a CBAM that is applied by one party? But if you have a new political climate and potentially a new government next year, which might not be so willing to diverge from the European Union, then again, those issues becomes pretty technical and can be settled. But I'd like to have your thought on this. And of course, as you rightly say, we lawyers always think about the worst case scenario. That's, I guess, or the way how we're trained.
Right. So I'm glad you asked me that question, because now I can plug another paper that I recently wrote, which looks at the interaction, the relationship between the Protocol Windsor Framework and the TCA. And in that paper, I make the argument that the TCA provides a legal and institutional framework which allows for a lot of flexibility. And a lot of the things that we identify as potential solutions to the complications and the difficulties which arise from Northern Ireland's post-Brexit regime, especially the post-Brexit trade regime, which is a very hybrid regime where Northern Ireland is subject to overlapping and often conflicting trade and regulatory standards, a lot of these solutions can be addressed through the broader EU-UK trade relationship. So you mentioned CBAM, and that's obviously a very obvious area where you can easily solve that by aligning the ETS schemes. You can look at other areas, for example, rules of origin, right? So the TCA, even though it's supposed to be this, very ambitious trade agreement, it has very narrowly defined rules of origin, which has a huge impact in terms of the GB goods that move into Northern Ireland and are deemed and do not comply with the tariff differentials and therefore are deemed to be at risk of being moved on to the EU. So that's already another obvious place where a reform of the TCA would allow to mitigate some of the barriers to trade that we see in the Irish sea border. And another area, even more obvious, is an SPS mutual recognition agreement, regulatory equivalence, which is something that the European Commission at one point said it was open to discussing. It is something that is universally supported by Northern Ireland business industries. And really the only actor that's been against it was the UK government, because, again, going back to this very specific conceptualization of national sovereignty, it is allergic to the idea of regulatory alignment. But again, that's something where if you have the political will, it could be easily done. It actually could be incorporated within the framework of the TCA, which allows for the negotiation and conclusion of supplementary agreements, which would fall under the institutional framework of the TCA, and which could act as a body which manages this trade regime on an ongoing, on a continuous basis.
Okay, thank you, Billy. Harold has got his hand up. Just to say that Daniela is connecting. I don't think she's connected just yet. So, Harold, if you have your question or comment, and then we'll see if Daniela has arrived.
Yes, thanks so much. And I just wanted to follow up on what Billy just said, because I think it's very important, and it reflects a kind of difference between the way in which economists thought about the trade issues and lawyers thought about the trade issues. And it seems to me, maybe this is a disciplinary gripe, but economists had a very, very misconceived conception of what trade negotiations in the modern world were about. And economists were still gripped by the idea that the big trade problem is about tariff rates and tariff levels. And so in that sense, it looked as if there was a very, very easy solution to the post-Brexit issue of just going to a zero tariff regime, and then you wouldn't need any inspections and so on. But it's not really about tariffs. It's about the origins, the safety provisions, all kinds of, and the more you go into climate change and the discussion of where goods originate in terms of the CO2 that's emitted during their production process, the more you're going to have to think about rules of origin story. And that is inescapably linked with inspections and as a consequence with differences. So, I think Billy was right to say that this is, in essence, a fundamentally insoluble issue, in that it is impossible not to have inspections in the middle of the Irish Channel if you go ahead with this regime, and there's absolutely no way of avoiding it, and the zero tariff solution solves absolutely nothing.
Yeah, and I think there is that sort of sense, just listening to the air, Harold, that it's certain solutions are kind of within a certain moment, and suddenly history or developments move on, and so we need to recognize the new problem. And as you say, for instance, climate change and where things are from and so on and so forth suddenly becomes the sort of signifier of value. But the solution we came up is 5 years out of date, by the time it's even implemented. I can't see if Daniela has come in yet, Federico.
She's trying to connect. I think she should be joining us very shortly. Okay. Just to say, she was on a delayed flight from Berlin to Athens, which landed with more than an hour of delay. So she's texting me to give me updates on how she's getting off the plane, and hopefully she'll be in with us soon.
Well, what did we all do before Zoom and had these kind of problems anyway? Right. Does anybody else have any questions or comments before Daniela arrives?
I can fill in the gap.
Yeah.
And just respond, just to complement with what Harold was saying, is that actually the TCA isn't a tariff-free agreement, right? Because you have such narrowly defined rules of origins, you do have goods that are moving between the UK and the EU that are subject to tariffs because they don't count as originating products. So actually the TCA, when you look at it in detail, is a fairly it's a very box standard trade agreement, really, that doesn't even fully remove tariffs. We still have significant, without even getting to the issue of regulatory barriers to trade. So it's definitely one area where there's a significant scope for improvements. And of course, with the added benefit that any further liberalization, any further removal of barriers to trade between the EU and the UK would also benefit Northern Ireland and its trading relationship with GB and the Republic.
But is there a sense then that these trade agreements, that it's all bogged down because I suppose it's still bogged down in the politics, let us say, as opposed to the economics, that it's the politics that gets in the way of solving some of these immediate kind of problems? Would that be the case, Billy? Would you think? You're on mute.
Yeah. So trade negotiations are very much about politics, right? I mean, if you look at the research on the actual benefits, economic benefits that you get from a bilateral trade agreement, they're very, very, very small. So quite often trade agreements are more about the politics, about promoting a relationship with a partner country. Definitely with respect to the UK and EU, it was very much informed by politics, because you're talking about two entities that were completely aligned from a regulatory perspective. And there was a decision to move from an economic relationship which was based on market integration to one that's based on trade liberalization, where you're essentially seeking to reduce border checks without addressing behind the border barriers to trade. And that's a political choice, right? It's certainly not an economic choice, because from economic perspective, it would make no sense to have two countries that are completely aligned to move from market integration to trade liberalization. Yeah.
Okay. Federico, any updates?
Daniela is struggling to connect. I'm not sure if we are fortunate to have her in or not.
Okay. Anybody?
Subsidies. I'm happy to step in.
Yeah, Andrea. Yeah. You have a comment or question, Andrea?
No, I just meant, I'm the first speaker in the afternoon in the next session. So
right.
if there's appetite for subsidies.
I think that's fine if Derek agrees, and I'm sure he will not object. We had 3 speakers and one didn't manage to make it, so we can probably move to you, Andrea, if you agree. So we keep the timeline for panel 1 until 3 p.m. Irish time, roughly.
Just thinking that she might need a moment, or I don't know.
Yeah. Okay, if we're good with that, I'm happy to go with that. You'll have to introduce yourself, though, Andrea.
Absolutely. Well, we're very fortunate to have a Professor Andrea Biondi with us. Wow.
It's the one time when you can say, is there a doctor in the house? Is there a doctor? Is there a professor here? Professor of economics by any chance? There you go. So
I can do the intro if you wish.
Very good, Federico. Okay.
So I'm delighted that Andrea is filling the void that Daniela is leaving. And it's my pleasure to introduce Professor Andrea Biondi, who is a professor of European law at King's College in London, where he's also the director for the Center of European Law at King's. which I shall say it's turning 50 years old next year. So obviously, the center was created in 1974, 1 year after the United Kingdom joined the European Union. And it is a bit unfortunate that you are celebrating the 50th anniversary now that the UK has left, but we're delighted that you're joining us, and you wrote an excellent chapter on subsidies and their enforcement in the Trade and Cooperation Agreement. So actually a topic that nicely links with what Billy presented in his work. So without further ado, I'll hand you the floor, Andrea.
Well, thank you, Federico, for the kind words. And obviously, we, some people suggested that we should have actually changed the name, but Central European Law and something. But we are pretty traditional, so we stick to the name that was chosen in 1974. Now I don't know whether I can share my screen or not. I'm disabled. Well, don't worry. I got some slides, but
I'll make you a co-host, Andrea. Sorry, so that's easier. You should do it.
There we go. Okay.
There we go.
There we go. Can you see it?
We can see it, and if you put it on slideshow, it will be even easier.
Yeah, I think. You okay? Now, obviously, it's quite a related the topic if you think about it, because obviously the question of public spending and state aid control has been massively discussed under the Northern Irish Protocol, so it's a little bit late. Now, my task was just a little bit of discussion on the subsidy chapter under the DCAA, and in particular, I think that the question that I tried to answer in the paper was whether the subsidy chapter does do enough as to ensure protection of the level playing field. After all, it's part, it's inserted in that part of the TCA, and in particular, whether it does do enough as to ensure that one of the parties that does not get a competitive advantage and undercut the others. Obviously, in terms of gaining a competitive advantage or undercut the others, I mean, to simplify, a couple of ways that you can actually do it. First, with a subsidy, you just give extra financial support to your undertakings or to your investors, or you can simply do nothing. Just try to, avoiding the cost of extra regulation by simply having an absence of regulation, or perhaps a deregulation, a process of deregulation. So the question is that, again, whether the TCA has done enough to tackle these issues. Now, obviously, we don't have the time, but just to remember again, even Billy mentioned that, where we started, and obviously state aid control was one of the biggest discussion. I put a couple of headlines. Those were the days when it really, state aid looked like enemy number one and stuff like that. And again, in terms of negotiating positions, couldn't, the UK and the EU could not be further apart. With the UK simply say, sorry, we need to approach the question from a very minimalist approach, just WTO model, and instead, obviously, the European Union insists on the preservation of the level playing field. So as I say, came a little bit of a surprise when we finally got the TCA, because within the level playing field part, the Chapter 13 is probably one of the longest and one of the most comprehensive one. And again, if you look at the 13 articles that compose the chapter, we go a little bit of a mini public subsidy state aid system in a nutshell. You have the provisions about the scope, and this is really an important point, because here you have a very well advanced definition of subsidy, which again is not just about subsidy on products, but it does actually apply to services. So I would simply say, generally speaking, to any kind of regulatory measure that can have the effect of distorting trade and competition. You have also long list of exceptions, derivations, specific provisions on sectorial subsidies, huge, many provisions on transparency, and also an extremely complicated web of enforcement mechanisms. So, a full-fledged sort of system. Now, to get back to my question, that is the chapter on subsidies enough as to preserve the level playing field? Just a couple of examples, because just really a very wide topic. Now, I think that one of the most intriguing provision, and don't worry, I'm not going to go through all this slide, is actually Article 366, because Article 366 says that basically, although obviously it does not actually say that any kind of divergence between the parties is going to automatically constitute an effect on trade and therefore a violation of the TCA, it simply lays down sort of a common framework whereby if any kind of regulatory measure decided by another party has to be compatible with all these principles. So in other words, the TCA already lists a sort of list of law. These are benchmarks called legality. These are benchmarks called legality. And I think it's more, the very extraordinary thing in my view is the fact that if you, again, for state aid aficionados, it's a pretty obvious point, but just to explain, I mean, all these very long principles are basically the ones that the European Commission has been using for 60 years to check the compatibility of national measures with state aid control. These are compatibility criteria that the Commission in reality, and then it's a well-known fact, use as sort of instruments to constrain public expenditure decisions of the member states and to address a little bit how money should be spent within the European Union. And here, from compatibility criteria, they have been elevated to parameters of legality. And it seems to me that the UK here has accepted quite relevant sort of limitation on their regulatory powers. We'll see. But then I think that's really one first example where I think that the chapters on subsidy does a little bit more than any other international trade agreements. Another example, because it's a very English problem, the UK and state aid control, they always had a very friendly relationship. In reality, apart from some old issues concerning Rolls-Royce or stuff like that, the UK never had massive problems with EU state aid control, with one exception. That is fiscal aid. Fiscal aid, obviously, we had a lot of cases, issues concerning sort of aggressive tax policies that the UK put in place. And obviously, one of the recurring themes of Brexit has always been Singapore on Thames, the idea of the regulation in the area of taxation and so on and so forth. Now, interestingly, in my view, once again, the TCA actually sanctioned the fact that you might actually have a lack of absence of regulation. In other words, that you can actually use your competence as not to tax certain kind of activities or not to tax certain kind of investors or companies. And as I said, it's very extensive provision, which simply clarify once again that a tax is actually a subsidy, and even if it's actually contained in a measure of general application, it will still be a subsidy if it actually has some kind of discriminatory effect, and therefore, if you can actually show that it does favor certain undertakings or certain investors. And I think that it's more even remarkable if you compare this very specific provision with a chapter of the TCA on taxation, which is very, very minimal. There's a laconic reference to international minimum standards like the OECD or the bilateral agreements, but nothing more. While instead, under these chapters on subsidy, we have really quite an extensive regulatory point. In terms of obligations, so I think that, on the whole, I think that there are quite a couple of good examples to show that maybe the subsidy chapter has done quite a lot in terms of ensuring the level playing field. There's a further obligation, and that's, again, pretty extraordinary because, the TCA requires the two parties to have an effective system of subsidy control, which means that for the UK, there was an obligation to come up with an entirely brand new system. So I think that here you have the first, to use a very Brexit term, you have the first example of a domestication of the TCA. Because now with the approval and the entry into force of the Subsidy Control Act of 2023, you have now a domestic system of subsidy control. Again, to cut a long story short, in the paper, I'm trying to test whether the Subsidy Control Act, that is to say, once again, the new system of domestic control, has actually done enough as to ensure the obligations that the TCA is placing on the UK. And I just mentioned a couple of points. I think that, again, clearly, each of the parties was free to decide what kind of model they wanted to use as to control subsidies. The UK decided not to follow the EU sort of system, so therefore you don't have a private notification, you don't have an independent regulator. You have a sort of a new system based on self-certification, whereby each and every one of the public authorities needs to comply with the 6 principles that I highlighted before. So in other words, they need to go through all the analysis that is actually contained in the TCA, plus even a 7th one on the PR. The public authorities also need to check whether the granting of a subsidy could also have an effect on trade and investment within the UK. Again, in my view, an extremely difficult task because, again, for instance, in order to evaluate whether there's a distortion of competition, they will have to enter into relevant market analysis. We spoke with some public authorities in terms of collecting information. It's a crazy task, so I don't know exactly how effective this is going to be. Another very delicate point is the fact that although the system devises a sort of a little bit of support for public authorities because they can actually send a proposed subsidy to the Competition Market Authority, to a specific unit. This specific unit has the power to draft a report, but this report is not binding at all. And I think that, again, there are quite a lot of concerns whether you can actually consider the specific unit at the CMA as an independent regulator, which, by the way, is once again provided by the TCA. And again, the very final point, in reality, the whole focus of the Subsidy Control Act is very domestic. It's incredible because it's supposed to be a full implementation of the TCA, but for instance, just to give an example, the CMA, the Competition Market Authority unit, has to check only if there's a certain kind of proposal of a subsidy might have an effect on trade investment within the UK, but no reference to possible impact on trade and investment outside the UK. Which then leads me to then, is that enough? Now, in terms of enforcement of the subsidy control, I think, again, it's quite intriguing to see that basically, under the subsidy chapters, all avenues are open. State to state model, so you can have an arbitration, fine, no problem. You can also have a fast track enforcement system whereby you don't have to wait for one of the parties that does not have to wait for arbitration, but can simply adopt immediately regulatory measures. You can also use the general rebalancing clause, which mostly is applicable to the areas of no regression, like labor standards and environment. And obviously, all these issues that we can maybe discuss even later, they're all subject to quite high standard of proof because it's not just enough to start the proceedings. You have to show that there's been a very negative impact, serious risk on the trade, and so on and so forth. But maybe in 2 minutes, I would simply just focus on number 4, which is entirely new once again, and it's a system of private enforcement. Again, Article 370, whatever, 3 of the TCA, simply and requires, requires parties to have a judicial review action. Simple as that. Which is quite remarkable because, of course, the TCA really wants to show his true public international law credentials. He keeps on repeating that it's not about creating individual rights. It's all about, within international law, and that's it, and that's all. However, under subsidies, you now have a specific action that any kind of parties can bring. I mean, basically, the idea is that a private party can bring an action before a court against the same authority that actually has granted the subsidy. Now, of course, here we're only speculating because it's really brand new. The UK has decided to confer jurisdiction on the Competition Appeal Tribunal. We had so far one decision only. So again, it's just a little bit like, I'm discussing it together with you. But I would just make 2 points. Now, first of all, in terms of procedure, I think the first, it was a case concerning, I think I have the date somewhere. It was a case concerning waste disposal in Durham. And I think that the appeal was brought around February. The hearing took place beginning of July, and the decision was actually rendered on the 27th of July. So extremely fast, very, very fast. Second point, that despite the UK intention that the CAT should simply check the rationality of the public authority decision, if you look at the decision, it's an extensive discussion. It's on the merit. It goes, you can disagree or agree on the findings of the tribunal, but it's a strict scrutiny. So my point is just really considering that all the other enforcement mechanisms are a little bit complicated to activate. For instance, the general arbitration mechanism, you cannot actually use it in order to challenge single subsidies. All the others, again, they're really subject to very high standard of evidence and stuff like that. Intriguingly, can we actually argue that perhaps the new private enforcement model provided by the Subsidy Control Act could actually be a rather attractive forum to dispute on subsidies? And again, if our concern is that the legislation has a little bit too much of a domestic focus, well, in theory, the Competition Appeal Tribunal has to ensure that any kind of measure is compliant with all the subsidy principles, which includes a check on whether a certain kind of subsidy can actually have an effect on international trade and investment. So could that be a sort of interesting possibility to start challenging a bit of everything? So again, you see that like any forms of private enforcement, one thing is to lose a trade dispute, and then maybe you have to show the you get to pay some damage or stuff like that. But another proposition is to lose cases before your domestic courts. So obviously, again, it's completely to be seen exactly what's going to happen. But we have a very interesting chapter which does touch upon so many things. And really, this is only for fun. I just thought this is all very good, but obviously, maybe in the next Fabbrini book, would also be interesting to see whether the EU is actually complying with the subsidies chapter, because there's so much going on that you never know. So that's it. Thank you.
Okay, thank you, Andrea, and thank you particularly for stepping up. I think that is a great sort of follow-on from what we were sort of thinking about sort of at high level into the sort of nitty-gritty of, I suppose, the law around agreements and arbitration and how things actually might work in the real world and how it might become an implement that can be used on both sides. And yes, for a little bit of fun, yes, it's all about the UK at the moment, but maybe to look at the EU itself. But any comments from anybody in the audience? I see anybody's hand going up there. Trying to look around. No, yeah, Federico.
Derek, I think maybe Elettra wants to ask a question first.
All right, Elettra, yeah.
Hi, thank you for Professor Biondi for your very interesting presentation. And I also have...
Introduce yourself, Elettra, so people know who you are.
First of all, I'm Elettra Bargelini. I am a PhD student in Dublin City University under the supervision of Professor Fabbrini. And my thesis is actually about the trade and cooperation agreement, and I'm dealing with subsidy control and the effectiveness of subsidy control under the trade and cooperation agreement. And I actually have a comment. So, do you believe that there is a chance that the provision of the TCA on subsidies, in particular concerning all the enforcement mechanism that we were looking at, they could be reviewed in 2015 and 2025 and 2026? And do you think, in particular, considering the global scenario on subsidies and how is changing also with the EU foreign subsidy regulation, like the European Union could have an interest in doing it?
Well, that was a little bit like my last for fun slide, because we need to acknowledge that things have changed quite drastically on the other side. Even before we had we mentioned the Inflation Reduction Act in the United States, all the initiatives taken by the European Union, and so on and so forth. So we are dealing now with a slightly different scenario from the moment of negotiation, but also in the entry of the TCA. I think that, again, judging from the European Union side, there are, before start touching the TCA, I think that there are few issues that the European Union would probably like to discuss with the next UK government on the Subsidy Control Act itself. And there are several issues that are on the list of the European Commission in terms, not just on the private enforcement model, which I think that everybody is actually now a little bit on the fence to see exactly how this is going to work, but certainly on the role of the CMA as a sort of independent regulators, the question of the possible exceptions that are listed on the Subsidy Control Act, and various other issues. I think that probably the first candidate for a little bit of a revision, rediscussion, would be informally, obviously, the Subsidy Control Act. So, of course, the European Union has got no power to tell the UK what to do. But I know for certain that there will be issues both within the formal scenarios and also informally that probably the certain things that can also be rediscussed under domestic control. And obviously the foreign subsidy regulation is completely another game, whereby you can also actually argue that the UK is a little bit now on the better side, because we can actually look like we are the good guys, because we know we have actually a system of domestic control. So once again, if the system of domestic control, it's a little bit like the point that we were making before with the discussion with Billy. If the Subsidy Control Act is going to be a little bit more successful than what we've actually perceived, I think that there would be a little bit less intense, with a little bit less tension. Let's put it like that.
And also, just a little, like, as we mentioned, the EU Foreign Subsidy Control Act, I think that also we will need to see if it will become an alternative way of dispute settlement or remedies. So which if they are going to apply the trade and cooperation agreement disposition or the EU
course. Again, sorry to keep on saying the same thing, a bit early again to understand. And I'm sorry, we are talking a little bit all anecdotal stuff, but again, the noises that is coming from the EU is that we're not going to go completely crazy about the foreign subsidy regulation. Let's see how it goes, So, but again, yes, it could actually become a bit of an alternative. But it all depends on many different factors.
Okay, thank you for that, Elettra. I think Pinar, your hand is up. Your virtual hand is raised.
Yeah, thank you very much, Chair. I mean, I think this was a fascinating presentation. Thank you very much. If I may say, Andrea, I very much enjoyed, because, subsidies in particular, both within the World Trade Organization and in the EU law, is a, dear topic to our hearts. it has become, super interesting, nowadays. So I'll have two actually questions. One of the things is that this Article 366, subparagraph C, where it talks about a kind of necessity test. So I was wondering whether you have any specific idea of how this necessity test will be applicable. Can we have, sort of mirror necessity test of the appellate bodies in the World Trade Organization? Of course, we know how the European Commission uses that, but I was wondering, are we going to need a sort of new necessity test? And my second question would be in relation to this new investigation that the European Union started against Chinese electric vehicles, which is, equally important for the United Kingdom, because EVs are, very dear to our hearts. And I could actually foresee a certain cooperation between the European Union and UK, because several German EV companies apparently are interested in opening factories in the United Kingdom. So my hunch would be that perhaps there is room for further cooperation between the European Union and UK in terms of subsidies, now that they are, fighting against this common enemy called China. I would love to have, to hear your views.
Yeah. Well, both excellent points. I think that, again, if I may, just to, we can even go a little bit further, because it's not just the issue of necessity. If you look at, I would simply say that the whole chapter is peppered with this little, with this, actually not little, it's quite big issues, whether we're going to, again, use the parameters that have been developed perhaps by the WTO stuff, or whether we're going back to the EU concept. And again, even in terms of definition of what is a subsidy, you have terminology which can a little bit borrow from both. In terms, again, of the compatibility, could be both. And I think that's really, again, quite an interesting point. I think that, again, at the moment, if I can just, I thought it was very interesting in a case that slightly involved before the British High Court. In terms of, we were discussing how the proportionality of a subsidy had to be taken into account, which is principle B. And again, the British court, although they were referred also to, appellate bodies and stuff like that, they simply say, well, why do we need to bother about that? We have, the European Court of Justice case law, we have the Commission practice. So I don't know. Again, it's an open question exactly which terminology we're going to adopt. And again, it's important because there are different implications. It's not this necessity under the WTO, necessity under what the Commission thinks in terms of state aid control is very different. I would simply say, again, with all respect to the agreement on countervailing, that the amount of expertise, the amount of concept, the amount of tools, the amount of guidelines on all these concepts on one side is really huge. On the other one, it's a little bit thin. So in terms of balancing, I mean, the EU law side is quite heavy going. The other point, I don't know, I really like also to ask your opinion, because in reality, the very first subsidy controversy was actually brought by the EU against the UK within the WTO framework on recycle, on green energy and stuff like that. And then, funny enough, the UK simply settled immediately the issue. They sent some very cooperative noises, said, "No, come on, we completely check." It was about conferring certain kind of advantages to local domestic companies. And again, there was a very constructive moment whereby the UK essentially said, "Don't worry, we just simply withdraw. We start from scratch." And obviously, the case did not even go to the panel stage. So again, perhaps you're right. Maybe there might be actually a moment of sort of joining the interest. And again, even to go back to that point on the foreign subsidy regulation, not necessarily the UK is going to be the primary target of the Commission. There might be, again, a moment of mutual interest and trust. And again, speaking from London, the atmosphere just a little bit better than what it was few years ago. Maybe our 50th anniversary might be a little bit more, celebratory than what we expected. But really excellent points. Yeah.
Can I follow up, Andrea and Pinar? That's a great conversation. I'm grateful also to Elettra for raising the point, because I'm not obviously a specialist on this specific area. I learned a lot by supervising Elettra through the work she's doing. But in a way, if I can build a bridge between your presentation, Andrea, and the one that Harold made, I think we are fortunate in the end that the two of you are in the same panel, because Harold started off by saying we're going through a new phase of globalization, and one of the key elements of this new phase of globalization is industrial policy, which from an EU state aid perspective, industrial policy, it's heresy, right? You could not even utter the word in Brussels because it would have been against state aid, right? The idea that the state intervenes in driving economic and industrial development. And so what I find very interesting about this conversation about subsidies is that we started off the negotiation of the TCA where Brussels was super obsessed and scared that the UK would be the country subsidizing industries, even though historically the UK was much more free trade and less Colbertist than continental member states. And now, of course, that the TCA is in place, the EU is going all in with this industrial policy strategy, which is now even presented as an economic security strategy. And so it almost feels bizarre, because you have all these mechanisms, this legal mechanism into the treaty designed to prevent the UK from, making the playing field uneven, as you explained, Andrea. But now it's more likely that it will be on the EU side, and in fact, it's more likely it's going to be the rule of the game for all Western democracies because of the reasons that Harold explained, where you have, technological transformation and movement towards sort of trade blocks. So, are we looking like at are we fighting the last war here, where there's all this discussion about subsidies, but we've moved into a new reality? I just wanted to bring it in, but I thought it was so interesting that Andrea and Harold ended up talking about this in the same panel. I think we were lucky in the end that this happened.
Okay, thank you, Federico. Billy, you've got your hand up.
Yeah, sorry, Andrea, for making this again about Northern Ireland and the winter.
Oh, sure. Yeah.
I bet you were expecting
each
this.
other next week.
So one of the things that really surprised me about the winter framework is that they did nothing for state aid. You had this joint declaration which restated things that were restated previously, and essentially saying, well, it is what it is. And it surprised me because there were actually some very good arguments for actually changing that regime. And a number of people have argued that actually this all could be covered by the level playing provisions in the TCA. So I was wondering what your view is on that, and whether you agree that the TCA framework is an adequate replacement for Article 10 of the Protocol.
Yeah. Again, because unfortunately, you see, the problem we have is that once again now we have all these different layers, because you have the TCA, you have the private enforcement mechanism, which, by the way, intriguingly, I don't know whether they realize it, but in theory, the Competition Appeal Tribunal can actually refer a question on the Northern Ireland Protocol, and let's say even refer a question to the Court of Justice. So it doesn't have to be a judicial review action before Northern Ireland Court. Can be directly pled before the CAT. So you might end up. And I think that we always felt that the TCA, because of the extent, because of the breadth, would be actually a sort of good replacement as to sort out problems. But then again, we really have a discussion. We had a discussion with the European Commission, and the official position that there won't be any issues on state aid control in Northern Ireland, because now it's very clear there won't be absolutely, and you agree, I agree with you that basically the Winston framework simply repeats exactly what we knew before. So in other words, again, was the battle on state aid control within the Northern Irish Protocol completely, nonsense? It was just, I don't know. But I think that again, and obviously there are ways also to deflate also the problems, because it's not true that effective trade it can be triggered by anything. So there are even legal arguments, but it seems to me that there's some sort of a consensus that we don't want to discuss it at all, because everything is solved. Although I say it would be nice to see the cat referring a question to the DCJ.
Okay.
And Andrea, on my points, do you have thoughts?
No, I agree. I mean, I can see that the last slides has been the most successful one, because you're right. And again, if you look at if you look at the points of discussion in the trade committee between the UK and the EU, I mean, the points with the UK, the free ports, the investment areas, they are quite minimal, right? Yeah, there are important issues, but they're not exactly the end of the world. Even under European law, you can have free ports and stuff like that. Well, obviously, on the other side, you have stuff like the CHIPS Act, which is really a heavy-going subsidy. A traditional 1950 subsidy. You just simply give money to specific producers. So we are dealing here with heavy-going industrial decision. Plus, and again, we are slightly diverging here, but clearly the fact that we've been applying on a sort of emergency basis state aid control now for 4 or 5 years or 6 years, whatever it is, and it keeps on, it's going to, kept on being applied on a temporary basis on a sort of emergency situation. Well, what's the outcome? That, of course, there's no, I mean, it's impossible not to say that state aid control at the moment has been very relaxed. So, yeah, the other side has some issues to deal with. Let's put it like that. And again, you can see, we are having this very informal conversation, but you can see the absence within the DG Comp of the UK officials, which obviously, paradoxically, have been the strongest supporters of tough subsidy control within the European Union.
Okay, Andrea. Harold, you have your hand up.
Yep, thanks. I just wanted to follow up on this discussion, because I think the point that Andrea made in that last slide is really a very powerful one, and we've come back to that again and again in the discussion. That it seems more probable that in the forthcoming period, there will be more state aid on the part of the EU members than on the UK side. And I think the explanation for it is, in a way, a kind of relatively simple one, and it goes back to the distinction that I wanted to make right at the beginning of my presentation between large economic units and small economic units. That if you're a large economic unit, the state aid story, imitating the US CHIPS Act or the Inflation Reduction Act, makes a great deal of sense. If you're a small country, it doesn't, and you really want to get the advantages that other people's state aid might offer to you. And so, in particular, you can, I think, work it out very nicely in the discussion about the electric vehicles. If China is really going to subsidize electric vehicle production on a big scale, it may be to the UK's advantage in terms of its consumers to have that access. You have a nice historical example, I believe, in the 1980s, when everybody was worried in a very, very similar way to the way that they're worried about Chinese vehicles today, about Japanese fuel-efficient automobiles. And the United States and the Europeans got very restrictive about that, whereas Switzerland, with no big domestic automobile industry, opened up, and so the Swiss market was really largely dominated by Japanese production at a time when the Europeans and the United States were trying to put brakes on that. And that would be the argument that the UK is more likely to go on that kind of low state aid route.
Okay, thank you for that, Harold. So listen, we're coming up to 3 o'clock, so we've actually come to the end of this session. Just to say that Daniela sends her apologies about her being unable to connect. And in that vein, to thank Andrea for stepping up and filling the gap there. So listen, it's been my pleasure to chair this session that's covered the local from an Irish perspective of the Windsor Framework, where we've had a situation where people can ask, what would Henry VIII do in this situation, and then act upon that, which I think is wonderful. So thank you to Harold for that overview of the reasoning behind Brexit. And then thank you, Andrea, for sort of getting into the nitty-gritty of trade agreements and that kind of interaction that from somebody who finds it comes out of a school of English and enjoys reading poetry. I think the legal texts around trade agreements are up there with some of the great modernist poets of our time. So listen, folks, I think Federico says you'll take a break for a half hour or so and have a coffee in the real world, and then that you can reconvene at 3:30, where my colleague, Professor Sharon O'Brien, will chair the next session. So hopefully the next session and the session tomorrow will be as good and exciting as this one. So it's been a pleasure to meet you all virtually, and hopefully we can meet in the real world at some stage. Okay. Thank you, folks. So Federico, will people stay on this link?
Yeah, thank you.
Yeah.
Thank you, Derek. So we will suspend the registration and then restart. Just would ask. Exactly.
Perfect. Okay, thank you, Federico, and thank you everyone who has joined us this afternoon. I'm delighted to be chairing this panel on the free trade agreement. So as you've probably heard, we have 4 speakers in this panel, and the sequence of speakers has changed slightly from the original program. We're going to start off with Pinar Artiran. I'll introduce Pinar just in a minute. Each speaker will speak for about 15 minutes, and then we'll do Q&A and discussion at the end of the contributions. So I will start by introducing Dr. Pinar Artiran. She is Assistant Professor of Private International Law at Istanbul Bilgiö University. She's also WTO Chairholder and the Director of the Research Center on International Trade and Arbitration Law. And she is the Faculty Erasmus Exchange Program Coordinator. Her research interests are on international trade law, law of the World Trade Organization, EU trade law, EU competition law, liberalization in network enterprises, state aids, development law, and political economy. And I believe that Pinar is going to talk about services, investment, and public procurement. So over to you, please, Dr. Artiran.
Thank you very much, Chair. I'll try to share my presentation while I'm doing. I will also take the opportunity to thank the Dublin City University and Brexit Institute, in particular Federico Fabbrini, who actually is a fellow former alumnus of the European University Institute. So I feel very honored to be here in his presence and all the very distinguished colleagues. And I will have a task of, speaking for about 15 minutes. So if you allow me to share my PowerPoint presentation, it will come in a minute. So, yes.
Your co-host, Pinar, so exactly, we can see it.
Yeah, I'm just doing it. Yeah, hold on for a second. I will just make it the presenter view. I think it works, right?
Yeah, that's perfect. Thank you.
Oh, great. Excellent. Thank you very much. So in the next 15 minutes, I'll have this task of talking about trade and services, of course, investment protection under the TCA and the public procurement. So as a roadmap, I would like to show you actually, what I'm going to cover within the, a couple of slides. I have only 6 slides. So as originally an international trade lawyer, I'd like to talk a little bit about how these things are covered within the GATT and the World Trade Organization, knowing that both the European Union and now TCA are regional trade agreements under the World Trade Organization system. How is it, that they are compared to each other? Is the coverage good enough? Is it less? Is it moderate? Is it ambitious? I'm going to talk about that. So the single market versus the TCA coverage will be meaningful in that sense. Then I'll try to cover, briefly trade and services provisions in the TCA, then the investment protection, including the dispute settlement related to investment protection, which is not very ambitious, we will see. And last but not least, I will also talk about the public procurement and the way in which, compared to the WTO GPA schedules of commitments, how the parties included public procurement in the TCA. So here it is important perhaps to mention that it has not been an easy task, of course, for the parties to come to a conclusion of having a free trade agreement and a customs union. And here I would like to mention that actually I had the honor of serving as a witness expert for the House of Lords and House of Commons on 3 occasions for Brexit, when I was invited to talk about the Turkey-EU customs union, whether it would be good for the UK to follow the footsteps of Turkey's experience with the EU, but it was obvious that Turkey's customs union experience so far has not been that impressive, because we have not been able to, remedy the situation, remedy many problems that we have. So, that was also very helpful for me to get into the, negotiations between the parties. Now, without further ado, let's have a look at how the GATT and the World Trade Organization, rules cover these 3 important items: trade and services, investment, and the public procurement. Now, it is important to first mention that, all of the regional trade agreements in the world are members. They have to be notified to the World Trade Organization for trade in goods under Article 2 and 4 of the GATT, and for trade in services under Article 5 of the GATT. So in this sense, the European Union, both the trade in goods part and the services regulations of the European Union for many years, including enlargements, were notified to the WTO as such. And of course, when the UK left the European Union, the trade and cooperation agreement, the goods part, had been notified to the World Trade Organization under Article 24 of the GATT, and the services regulation has been notified as an economic integration arrangement. That's the official name of a services arrangement under the regional trade agreements, has been notified duly to the World Trade Organization. So in that sense, there is a wonderful analysis of the World Trade Organization. The Committee on Regional Trade Agreements has prepared a very good summary of the TCA. Those of you who did not have a chance to look at it, I would highly recommend to go to the WTO website and see this summary and the overview in comparison with the other, regional trade agreements in the world. Look at the WTO factual report on that. And of course, for investment, we have an agreement in the World Trade Organization called TRIMS. But the way in which I'm going to look at the trade and cooperation agreement will be on the basis of the GATT's commitments, GATT's Mode 3, because the trade and services in international trade are regulated under 4 modes of supply, and investment is covered under the 3rd mode of supply. So commercial presence, investment, whether is it good enough under the TCA, the investment protection or investment freedoms that are provided, I will look at them. And of course, the GATT, the WTO, is regulating public procurement under a plurilateral agreement, which is called the GPA, Government Procurement Agreement. So it will be important to see under the TCA, what are the commitments that the EU has given to the UK, which is going beyond what it's already given by the EU to other countries under the GPA of the World Trade Organization. And similarly, because the UK is no longer a member of the European Union, it has joined the GPA which is a plurilateral agreement. Again, it is not a multilateral agreement. You are not obliged to join the GPA, even if you are a WTO member. But of course, the UK, caring deeply for public procurement, and of course, it's part of the negotiation with the European Union, also joined the GPA, and it is now in its full right a member of the GPA. So, of course, while we are looking at all these things, we need to remember, what was the default position for the parties, both for services, investment, and public procurement. In the EU single market, we all know that the basis of the EU single market is the freedom of establishment. For any economic operator that is going to function as a company or as an undertaking, the ability to go without any restriction requires the freedom of establishment. And similarly, even if you may not be a real company, but you may be a simple service provider, like I can be a professor, I can be an artist, but I can, move freely within the European Union if I am a service provider. So these were given in the European Union. And for public procurement, even though it is not as harmonized compared to the rest of the internal market operations, we can safely say that the public procurement has already been heavily regulated. But again, with the caveat that I would like to mention that public procurement had some shortcomings within the European Union as well. It is one of those areas that countries, even in the European Union, tend to be very protective of their own companies, whenever they are in the bidding process. So, but, compared to the rest of the world, of course, the European Union is much more, harmonized within the context of the public procurement, but not to the extent of course, the experience that we would expect from countries within the European Union. Now, compared to that, we see that, trade and cooperation agreement is partly ambitious within the, general system of services, investment, and public procurement. And I'm saying this because, when you compare not only the EU single market and the newly formed TCA, but also the European Union's trade agreements with other countries within the World Trade Organization. Here you can talk about CETA, the free trade agreement with Canada, or the one with Japan, etc. And this is all despite the fact that, these countries, well, on one side, the European Union and the United Kingdom were married for a long time. So divorce, of course, has been very difficult, but that doesn't mean that the countries would not like to have certain, chances and opportunities that they would like to use, because at the end of the day, both of these entities, the European Union and UK, are super ambitious and they are super intertwined at the same time. So that's why you would expect an agreement which would help them to go on with this kind of, intertwined development of economic integration, but it's not as easy as possible. Now, let's have a first look at the trade and services very briefly. As I said, this is modest compared to the single market regulation. We actually see that the TCA is pretty modest. In particular, considering that financial services is super important for the United Kingdom, especially the City of London, but also for European operators, we see that there are lots of reservations made by the EU member states. And actually, if you try to make a Google search for all these articles which appeared in Financial Times over the last 3 years, there are plenty of articles which actually shed light on how many financial institutions moved from London, in particular from the United Kingdom, to the EU member states, in particular to France, to some cities in Germany, in order to benefit from the equivalence opportunities that may arise, because unfortunately there are no passporting rights, as we know, so far within the TCA. Now, those passporting rights, of course, are very important. By saying passporting rights, we're talking about, within the European Union, the possibility of, going to a member state of the European Union and provide your financial services without necessarily, facing very much hurdles. Your life is being facilitated because, after all, this is a single market. But now that, the parties are no longer attached to each other within a customs union or within a deep integration, they are bound by a free trade agreement. Those financial institutions in the United Kingdom, for them, it makes more sense to have a commercial presence in the EU member states under the Mode 3 of the GATS. That's what I'm going to say, because, if you cannot have a, full-fledged, perfect free trade agreement, with your partner, which is unfortunately not the case yet for the UK and the European Union, you can still benefit from the commitments that are delivered under the GATS. And so for that occasion, the third mode of supply under the GATS for commercial presence, that is a sort of investment, makes sense for all these financial institutions, financial service providers, which do not have passporting rights. And, in the absence of any equivalence that is provided by the European Union for the UK companies, this is one of the options to overcome the hurdle that exists in relation to imperfect financial services. But on the other hand, let's not be very cruel towards the parties, because in the telecommunications, they are super successful. The agreement goes beyond what is expected compared to other free trade agreements that you see in the world. So for telecommunications, it is obvious that they made their full effort in order to, have these, free connection between the parties. But for instance, I would not be able to say the same thing for audiovisual services, which is a little bit pity for the United Kingdom, considering how the United Kingdom is ambitious in audiovisual services, certain, state companies like BBC and other, productions that they have. And another super important problem that we have is the mutual recognition of professional qualifications, and labor mobility doesn't exist there. Now, mutual recognition is always difficult. Even within the EU single market, it took ages for many member states to come to terms with the, mutual recognition arrangements, but, they are there now. Life is easier, also with the help of the Court of Justices, very important judgments in relation to the mutual recognition. But when it comes to the TCA, we actually see that, this could be one of the ways in which they can solve their problems by signing mutual recognition arrangements. But unfortunately, those arrangements are not there. And why is not there? Because it is up to the European Union to make its mind, especially in particular in 28 different services sectors, in order to grant those mutual recognition agreements, but the EU is not there yet. I'm sure they are working on it, and there will be a time where we can talk about these mutual recognition arrangements. But as we speak, it's not there. And similarly, the labor mobility, it's not very, going forward within that angle either. Now, when we come to the investment, it's bizarre, I find, this agreement, because investment is such an important part of international trade, and is being regulated not only under, separate chapters of free trade agreements, but also through BITs, as we all know. But when you look at the TCA, trade and services and investments are intertwined in one single part. I would expect as a lawyer to have a separate chapter on trade and services, separate chapter on investment, considering the importance of both these important, fields. But the drafters, negotiators have opted for a mingled, part in the trade and cooperation agreement. And moreover, the investment protection provisions are super modest compared to the BITs or different, free trade agreements investment chapters that we see. Of course, it comes with a non-discrimination principle, MFN and national treatment. And more importantly, it is coming a very, super important topic, right to regulate. It has been embedded into the trade and cooperation agreement. So it shows how important this right to regulate or the policy space argument for the parties. But it is a super, interesting point, and it's mind-boggling, I find. There is no protection given to investors against expropriation, no guarantees for, fair and equitable treatment, and there's no full protection or security. There is absolutely no ISDS mechanism, so the investors do not have a right to bring a case against the host state. And there is only state-to-state arbitration. But of course, here we need to, be mindful about the European Union's inspiration or aspiration to create a multilateral investment court. And it is very difficult. We all know that the US is not interested in that, and perhaps UK is on the same board. But that is a whole agenda that will need to be addressed in the future. And another point, last but not least, the intra-EU BITs that exist, that where the Court of Justice had ruled that these are incompatible with European Union law in the famous Achmea case. And so in accordance with this decision, judgment of the Court of Justice, some of the EU member states have terminated their BITs with the United Kingdom, but there are still a couple of EU member states which have not terminated their BITs with the UK. But considering the Court of Justice's judgment, pertinent judgment, we don't know what will happen to those BITs. Now, the public procurement, very briefly, as I said, this is probably a better arrangement compared to trade and services and investment chapters. I like it better. Why do I like it better? Because the parties go beyond what they have already promised within the World Trade Organization GPA. So it actually shows how much it will be important in the future having access to each other's public procurement markets. And because the United Kingdom is now party to the GPA, we have a possibility to compare the commitments given by the UK towards the European Union within the GPA and the UK's commitments within the GPA. You actually see that these commitments are better when it is granted to the European Union. And there's a larger scope for covered procurement. So the scope of application here is better. So it's a good thing. So this is what we like in free trade agreements. Transparency is crucial. Non-discriminatory framework, of course, for public procurement is key. But also I have to say that security and general exceptions, as usual, because this is a public procurement, they have made the case that this will always be applicable to all types of procurement. But in particular, the national treatment, which goes beyond the covered procurement of locally established suppliers, is a possibility that is granted there. And one of the things which is in line with the current developments in our economies in the world, digitalization, you actually see that this chapter on the public procurement gives lots of emphasis on electronic procurement, transparency in electronic procurement, and also for some companies, medium-sized enterprises, which may not necessarily be very good in dealing with electronic items. The parties want to make sure that the governments or public authorities which are going to come up with public procurement have to make sure that no one is left behind. So you have to create a system which is accessible for all candidates for public procurement. So in conclusion, what I think my takeaway from this these three chapters, the trade and cooperation agreement for me is just a start. Brexit is an unfinished work for me, and the EU single market, even if it was the no longer binding force between the UK and the EU, the TCA does not have the magic formula either. We need to really go through, the parties need to go through to really iron the certain frictions that exist, in particular in relation to trade and services. As I said, not having passporting rights is a major problem, so the liberalization efforts have to go further. And in that sense, the review possibility every 5 years for mutual recognition and mobility arrangements, I think will be crucial. So the parties will have to work on it, because just like in majority of EU's trade agreements with third countries, you also have a rendezvous clause in the TCA where they will have to go through certain things. But please do take notes, and I have written on the slide that financial services are excluded. So this rendezvous clause does not include financial services. So it seems that the parties, in particular the European Union, is not very keen on revisiting the norms about that. And last but not least, the trade and cooperation agreement is good for an orderly separation. So it's not a no-deal Brexit, but we have to expect some further negotiations down the line. Thank you very much.
Thank you very much, Dr. Arturan, for that contribution, and lots of interesting detail there, I'm sure, for all of you who are in this domain. So we're going to move next to our next speaker, which is Professor Elaine Fahy. A little introduction to Professor Fahy. She's Professor of Law at the Institute for the Study of European Law at the City Law School in London and Deputy Head of Department at the moment. She's been co-convener of the Institute for the Study of European Law since 2016. In 2022-23, she was the Senior Land Steiermark Fellow of Law and Innovation at the University of Graz in Austria and a visiting professor also at Washington College of Law. And she has practiced as a barrister and was chairperson of the Irish Society for European Law. Her research interests span the relationship between EU law and global governance, trade, transatlantic relations, the EU's area of freedom, security and justice, and the study of law beyond the state. And her monograph was published in 2022, which was entitled The EU as a Global Digital Actor. So I'll hand over now to Professor Fahy. Thank you very much.
So thank you very much for that. With some trepidation, I give this presentation because Federico, in his effusive manner, asked me to consider transnational areas in the TCA, and I immediately was perplexed by this as to how I would deal with this very difficult task, since the concept of the transnational is a very divisive and contestable one, something that's very close to my heart. But as a matter of strictly speaking of EU trade law, is not a word. Transnational is not something that you find in EU trade law, shall we say, generally. So thank you so much, Federico, for giving me the challenge, which I took up perhaps a bit too eagerly. And I apologize for missing some of today's induction week here, but I can't think of anything I've read in my life so far, if I can be as bold as that, to make such a grandiose claim, as Harold James's chapter on Brexit. So it was really, it was an epic read. So thank you, Federico, for assembling this in one of your many ventures. So I'm just trying to change the slides. Yeah. So I suppose I start from the premise, and I come at this from the perspective of international relations, global governance. The TCA is there's a lot about Brexit. There's a huge number of nuances and chaos to it. But in strict terms, it's not a terribly interesting fact of international law, international relations. It's a very dull, unambitious agreement. So again, when Federico put the challenge to me, I suppose I'm very interested in how the EU projects itself globally, the EU's internationalist, globalist ambitions, and for all of its terminology and its desire to be this global actor. The word transnational, as I said, is not something you find in trade agreements, and there's only one mention of it in the TCA, to the best of my knowledge. But again, I'm slightly Zoom blind at the moment, and there are very few genuinely multilateral engagements in the TCA, in my opinion. And I've mainly done a lot of work on digital trade and cybersecurity, and those are areas that you see lots of references to multilateralism, precisely because they are international, global problems that it's very necessary to have that broader ambition. But of course, the general lack of ambition reflects the TCA, a very rushed agreement, and most external relations lawyers, are heavily critical of the strange oddities of the TCA, how much was put into it, the competence questions done really well by a variety of people. But I suppose, I think, as the last speaker also adverted to, there's a very important dimension of the TCA, and that's its contemporary use of lexicon, and labeling things as digital trade, not e-commerce and so on. So as I said, Federico gave me a big challenge, and I, in my naivety, said, well, what about cybersecurity? I think you said energy and climate, and I'm terribly nervous of writing a full chapter on this, because certainly health and energy are not things that I've done quite a lot of work in cybersecurity, a lot less so in climate, and even less again. But I kind of wanted to take the challenge, and I think it's a very interesting question about the depth of international cooperation. And it's also even more interesting where cyber and health are put in the TCA at the back of the agreement, as it were, in a very unimportant place in the agreement, just to reflect the lack of ambition. There were areas that are very important at the time, particularly during COVID and so on, but even dominated by geopolitics, they certainly are lower order issues, and I think we can't escape those framing issues as to the TCA generally. So I'll jump right in the interest of time. I suppose the climate questions of the TCA I find quite fascinating. People like Marcus Gehring, really great international economic lawyers, would say, despite the really bland, unambitious nature of the political declaration preceding the TCA, the withdrawal agreement, it's extremely innovative. And the references to the Paris Agreement are obviously the most important features of the TCA, and a whole variety of mechanisms for it to arise. In fact, I count on my Control F very extensive searching at least 9 mentions of the Paris Agreement, particularly as to trade, as to the fight against climate change, and as to fulfillment of ambitions or obligations. And I think that's important to say, that it's a kind of a cross-sectoral dimension to climate. And I've got a PhD student who's looking at the intersection between the internal and external of climate law. And it's a very difficult question for the EU, the placement of climate. And I do a lot of work in transatlantic relations, as your colleague has said. And that's also something with the US had to bring the green questions into trade and technology has been very difficult, also for the EU as a matter of framing. But of course, most trade lawyers get very excited about or had to write about the complexity of the level playing field provisions of the TCA, in particular. The idea of safeguarding fair competition and evolving TSD has been a very important question of the characterization of the TCA. So you see things like this, trade and climate change is provided for Article 4.01, explicitly mentioning the Paris Agreement, also the very basis for cooperation, referencing the fight against climate change as being its own specific clause. And it's very difficult, I think, in the midst of the complexity of current relations and the souring of relations, and then the realignment in more recent times, not to forget that these were very important and innovative provisions. And as I said, the level playing field dimensions, fulfillment of obligations in Title III, putting this as an essential element of the TCA is also, from a legal perspective, also a very, considering these questions to be serious and substantial failures. And I think people like Marcus Gehring and so on have written, in a lot more detail, and have very important views on what, the clarity and the certainty and the difficulty of all of this. But I leave that to one side. I try to be quite descriptive in the chapter overall, just to sketch these questions rather than to engage in more prolific debates. I suppose then to jump straight into cybersecurity in the interest of time. Cybersecurity is a really fascinating question of Brexit, because the UK was one of the leading protagonists of cybersecurity in the EU and intelligence-led policing. And as many of you will know, cybersecurity in EU law now traverses everything from the internal market to cyber sanctions against Russia. And whilst the TCA is very boring as regards foreign policy, one of the first things, of course, that happened after COVID and Ukraine crisis has been to see the UK align voluntarily with the EU and US, in particular as to cyber sanctions. We don't have a global cybersecurity agreement or a global privacy agreement. And there's a really odd relationship between lots of trade agreements and the term cybersecurity. So there's so many different types of framing of cybersecurity, so many definitions, so many strategies. But the EU is definitely at the vanguard of blocks in seeking to develop new policies, and to have an agency, an act, and this the Internet of Things is really important. So the EU is very doing very important work on trying to regulate a vast number of users, to have binding rules. Still different to the US, lacking federal law and so on. So the TCA is quite interesting for a number of reasons, as to the place of data, as to the exceptional commitments to multilateralism in the cybersecurity section, as to the depth of detail provided for in that section, but largely being disappointing because of its absence of co-relationship to digital trade. And I think there's lots of people have written this and said, well, really a lot about the TCA can be explained as to its rushed nature. And there are threads of interesting elements as to multilateralism, but ultimately we can see that it's very much a rushed treaty, and it's hard to, our rushed agreement is hard to to define it otherwise. It's also very important to say that the transnationals to cybersecurity has become extremely important across borders, particularly as the Council of Europe and the Budapest Convention, the protocol there, e-evidence developments, and the EU using everything from the internal market to the CFSP. So getting the UK's position on board in all of this is really quite interesting, and it's important to see it in the TCA. And also just from an international perspective, the number of organizations that the EU is really trying to push for its position in it generally has very good representation in a lot of key international fora, and as some people would even make the claim, such as Ramses Vessels, that it's the most significant international policy field of all time. So just very briefly, what's really interesting about the TCA is the EU's institutional infrastructure as to cybersecurity comprises its agency, which is ENISA, a response team, CERT-EU, and the developments as to ENISA as a proper agency, the agentification of EU law. And all of this is a pretty robust set of developments as a matter of internal market law to get cyber policy to this nature. So sorry, I'm being very long-winded as to something that's close to my heart, but in essence, cybersecurity isn't a dull part of the treaty, the thematic cooperation, but we've never seen it before like this, and we've never seen so many provisions in a trade agreement, including on dialogues, cooperation, and more importantly, lots of voluntary participation capacities for the UK to jump into all of these institutional elements, for example, ENISA and CERT-EU. And I think those are really interesting provisions. It's a very striking situation where it's not framed in the strongest possible terms, but it's very much open and participatory. And you'll see that there's about 17 references to the term cyber in the TCA. So just on a very descriptive, boring basis, it's something that clearly was a successful part of the negotiations. But you see, it dovetails, it's under health security, and I'll come back to that in a moment. And yeah, as I just mentioned, I think the nature of the dialogues is really interesting because you don't have that, for example, in the digital trade chapter. And it's not to be forgotten that the UK has lost its seat on Europol, lost a lot of opportunities to shape pan-European policing. A lot of those in the cyber communities are very sad about its role in cybercrime operations and in ENISA generally. Okay, very, very briefly on energy. Energy is one of these areas of the TCA that's there's so many questions as to how energy arises in social and environmental issues, so many issues as to subsidies, as to dual pricing. And I think from the TCA, strictly speaking, it has some pretty esoteric forms for engagement. For example, Article 321 on the development of offshore energy, but it also, more importantly, has an institutionalized structure to cooperate. At a meta level in the Partnership Assembly, where there seems to be some interesting discussions ongoing as to renewable energy, as to joint projects. There's also obviously a specialized committee in energy that has obviously been dominated by the Russia's war, the Ukraine crisis, and there has been a lot of interesting efforts as to reference coordination at an international level, particularly at G7 level, international agency cooperation. So I think just on a descriptive basis, it's a lot shorter. It's a lot less. It's obviously leaving the EU's energy market has had a profound effect upon it. But it is obviously at the timing that it arises as to the Ukraine crisis quite important one. And I think I'll try to I'll just very briefly sketch health. So I think Federico asked me to discuss this, and I have a lot of specialist colleagues who do EU health law, so with great trepidation I speak about this area. And I think health is a really interesting question about characterizing the TCA as being extremely unambitious, because health lawyers will tell you EU competence in health has always been evolving and certainly growing, particularly in Article 168 of the TFEU, but there's been a lot of limitations, and obviously the free movement of people is very key here, and relevant legislation. I think Mary Guy puts it really well that the history of EU health law is very much less about a unified EU policy than a very complex system of partial overlapping national and EU competences. And I have a fantastic colleague, Professor Tammy Hervey, who does also a lot more in this, and this is very much the story of EU health law. They will tell you now. So obviously, the TCA, I think most people will be aware, has been very problematic from the point of view of medicines and the sale of goods, particularly as to Northern Ireland. I leave that park that totally to one side. But there are, very important questions about the parallel regulatory processes that emerge and the divergence that is enabled for the UK on medicines policies, particularly as to devices, clinical trials, and just more broadly about the international consequences on losing out on cooperation opportunities in international organizations, but particularly particularly as the Northern Ireland question, I think, has proven to be quite. Mark Fleer in Queen's University Belfast is doing a lot of work with my colleague, but also Nick Fahey on this, and I think they have put it very neatly in saying Brexit really changes the UK's relationship with all the fora internationally where it was previously represented by the EU, particularly in bioethics, the pharmaceutical industry, and in that dimension is not necessarily operating under hard competences. The internal market is not necessarily being so dominant, but more the international fora and the questions of how to coordinate remain much more in flux and remain subject to a whole variety of other factors. And I think, and I'm in discussions with Mary Guy has been very helpful on this paper, because this would not be my core area of research, but she's been fantastic in just advising, and of course all disclaimers here. But I think on pushing the questions here of how esoteric each of these situations is. The pharmaceutical questions are very different to the regulatory and bioethics. This whole very parallel debates, as it were, taking place, if I understand the literature correctly. So I'll attempt to summarize that as best as I can. But I suppose the other interesting question about the TCA is that there's literally only one reference to the transnational in the entire agreement, and that's actually in Article 85 on cooperation on antimicrobial resistance, which again demonstrates the kind of the backfooting place of health and all of this, but obviously propelled centre stage by the complexities of COVID. It's not just present a picture of completely doom and gloom, though. There's a lot of intentions to cooperate, lots of important references to the an early warning system and health security, exchanges of information, and there clearly are provisions for collaboration and sharing information in a global health crisis. And I think sharing information sounds like a very dull thing, but that is a core question of how global governance, effective global governance works. That sometimes these looser forms of collaboration can lead to stronger relationships, and in particular the UK can request access to the early warning and response system and to participate in the EU Health Security Committee. So there's lots again of entry points into broader relationships. So my very tentative conclusions, I think I'm supposed to have fundamental conclusions reached by tomorrow or something terrifying that Federico said to me, but I would certainly say that the cyber elements of the TCA probably are the most exciting and make the most detailed forms of cooperation for very concrete specific participation. But maybe I'm not, maybe things like the health cooperation and in fact are probably on a par, and I'm over emphasizing, I think the British say over egging the pudding in this respect. There's also very significant institutional cooperation and participation in the grander scheme of things, in a very thin agreement, and there are commitments to multilateralism. And there are commitments to engagements, although it's not the regulatory cooperation that we might be used to seeing in trade agreements, but it's also very noticeable for the breadth of cooperation in cyber, for example, couched in institutional conclusions. But I mean, we can't get away from the fact that foreign policy is largely excluded from the relationship, and the EU is a very powerful actor, for example, in areas of such as cyber sanctions, and the things that are on the margins of these competences are much more important to consider going forward. And obviously climate it seems to be a very significant area for cooperation, where you have it underpinned by the brute force of the level playing field provisions. So with that, on my very whistle stop tour, thank you very much for having me speak, and I'm looking forward to chatting further. Thank you.
Thank you very much, Professor Fahy. You've covered a lot of really important topics in 15 minutes in a very interesting way. So thank you so much for that. We're going to move on now to our next speaker, who is Dr. Niall Moran. And Dr. Niall Moran is Assistant Professor in Economic Law in the School of Law and Government at DCU. He has a PhD in International Economic Law and has worked for the Legal Service of the Council of the European Union and the Bilateral Relations with the Americas Unit at DG ARI in the European Commission. He's author of Engagement Between Trade and Investment Law, the Role of PTIAs, that was published by Springer in 2021. And his research interests include EU law, international trade law, WTO law, international investment law, competition law, equity and trade and investment in agriculture. So we'll hand the floor to you now. Niall Moran, thank you very much.
Thank you, Professor O'Brien, for the kind words and introduction. Thanks also to Professor Fabbrini for the invitation to contribute to this volume and speak here today. I was very sorry to miss the first speaker, most of Professor Artaran's speech, so I look forward to hearing about services in the Q&A. But as mentioned, my chapter looks at trade in goods under the TCA. And in my talk, I'm going to give a little background before focusing on 3 specific topics in this area. So firstly, I'm going to look at trade in electric vehicles, and this has been the subject of some intense speculation in recent months. Secondly, I'm going to look at how did the TCA's rules on trade in goods impact the place of UK manufacturers in European supply chains, and both of these topics are discussed with reference to rules of origin. Thirdly, I'll be looking at how trade in goods encompasses SPS and TBT requirements. This may not sound particularly riveting, but food safety and animal welfare standards are also very important in the context of the EU-UK relationship. And I think a common thread in these 3 areas that I'm going to discuss is that the gains of increased cooperation are really tangible. They're there to be grasped by the EU and the UK, but the ease of bringing about further cooperation varies. So on EVs, electric vehicles, a deal seems eminently doable. On maintaining the UK's place within European supply chains, I think a deal should be doable. And on an SPS agreement, here a deal might be a bit trickier, but I think it's also doable, being the optimist that I am. So for each of these areas, I'm going to look at where we are, what could be done differently, and whether there is the will to bring about closer cooperation. But to start with a bit of context or background for my chapter, trade in goods, I think it's fair to say it's the backbone of the TCA, as it is indeed the case for any trade agreement. Title 1 on trade in goods, it's about 1/7 of the entire TCA, and there's plenty of detail in its 108 articles. And these details wherein the devil lies on rules of origin, SPS, rules of etc., they take the gloss off the label that the TCA provides for tariff and quota-free trade. It is tariff-free trade, but you have to qualify for it, and there are certain exceptions for trade in live animals, etc. So a final point on the background is that it's a minor miracle, in my view, that EU-UK trade in goods has remained as deep and stable as it has. If you think back to November 2016, the future trajectories of the Trump administration and Brexit, they were somewhat unknown, it's fair to say. And while there has been a lot of brinksmanship over a no deal or the triggering of Article 16 in the intervening years, EU-UK trade has remained in a relatively good position, and the TCA has been a crucial part of that. We haven't seen the level of friction, such as the US-China trade war, and compared to the direction the US has taken, discussions on whether the UK will join the PEM Convention are welcomingly banal. Banal, but not trivial. So while there has been a regression in EU-UK trade in goods compared to the status quo ante, the TCA has helped minimise disruption. So going to my first point on electric vehicles, this comes under the section on rules of origin in my chapter. And these are rules that must be complied with to avail of tariff-free trade under the TCA. So very briefly, for a good to be from the EU or UK under the TCA, a certain amount of the materials in the good must originate from the 2 parties. So this number varies from 30% to 70% for different goods. For battery packs used in electric vehicles, the rule will kick in from 2027 that only 30% of its value can originate outside of the 2 parties, 40% from next year. For other products, up to 70% can be from outside the EU or UK. So electric vehicles are unusually exposed to rules of origin. And this is because the price of a battery in an electric vehicle makes up such a significant proportion of its overall value. It's at least 30%, in some cases over 50%, and European batteries or UK aren't currently available. They're sourced from China, Japan, etc. So from January 2024, the amount of an EV that has to come from the EU and UK, it's going to shoot up. And the logic behind this is that it'll force car producers to source batteries locally. But if they can't source enough of the material locally and the rules aren't changed, EU-UK car exports are going to face tariffs of 10%. And to me, this calls into question the label that the TCA is of an unprecedented ambition. The EV market, it's already in the tens of billions per year, and you can expect trade diversion if these tariffs kick in. So there is a hotly debated question at the minute of whether to allow the TCA to enter this new phase or whether to amend it and extend the current rules on rules of origin here. So Commissioner Breton has said that we can't alter the Brexit deal to appease the car industry. But I don't think legal certainty is the most convincing argument when you're faced with a lose-lose proposition such as this. Germany, the UK, and the car industry, and other industries, have come out favouring an extension and the maintenance of current transition rules, at least for another few years, until batteries can be sourced in the EU. But if no extension is granted, and there's only a few months left to come to it, it has to be said that this serves neither industry nor the EU or UK. It's also an inconsistent message to send to introduce tariffs for electric vehicles, but not for vehicles with combustion engines. The green transition is challenging enough without own goals like this. So I would expect a deal in this area to be reached before the end of the year. We want the UK to listen to industry in these areas, and the EU should also do this. I think not extending the deadline would send a negative message, and showing this flexibility in an area of mutual benefit, I think, would go a long way. So there's also a strong case to be made for integrating the EU and the UK in EV supply chains, and this would help. A final incentive on the EV point is that the EU's recently announced anti-subsidy investigation into China. So this could lead to Chinese cars being diverted to the UK market and further losses for the EU car makers. So this brings me to my second point on how the trade and cooperation agreements rules on trade and goods impact the place of UK manufacturers in European supply chains. So the single market, it represents the deepest level of economic integration among nations that we've seen, certainly at its current scale. Brexit was an unprecedented divorce in trading relations. And while the TCA, it was ambitious in some respects, the description might be optimistic in other areas. It's ultimately a regression, significant one, on the EU single market. And in today's geopolitical context, we're seeing increased cooperation between like-minded allies, talk of de-risking supply chains. And in this context, the main issue with even the prospect of UK divergence from the EU is that it may undermine the ability of UK manufacturers to remain firmly embedded in EU supply chains. So one example here relates to processing. If there's insufficient processing, a good cannot be re-exported back to the EU tariff-free. So there's an incentive to onshore and to take the UK out of the supply chain. To remain integrated in EU supply chains, components must be able to move freely back and forth. And this is also important for intermediate goods, making up about 50% of UK manufacturing exports to the EU. So the House of Lords have called for an exemption, and while this is common sense, at the end of the day, the UK, it is a third country. And the risk for the UK is that supply chains will shift into the single market due to regulatory uncertainty. For long-term investments, there are doubts about whether those will be made in the UK with the current situation. So I set out in my chapter that a significant step to the UK securing the future of manufacturers in European supply chains would be joining the Pan-Euro-Mediterranean Convention on Rules of Origin, the PEM Convention. The UK is considering this. It hasn't ruled it out, but I think there appear to be misgivings, in the initial phase of Brexit to sit back, see if we could do something different. But ultimately, I think we're 7 years in, and the benefits appear to outweigh the drawbacks considerably here. There's also the point that joining wouldn't be a foregone conclusion, as it has to be approved by the membership, some 50 countries, but it would be a step in the right direction, and I think it probably would happen. It wouldn't be a panacea, but it certainly would be a good step towards embedding UK manufacturers in EU supply chains. So that finishes the second point. The third point relates to SPS requirements mainly. So the market access section of the Trade and Cooperation Agreement provides for tariff-free trade unless otherwise stated, and it prohibits customs duties on all goods in the other party under Article 21. So many of the provisions impose identical obligations to the GATT at the WTO, incorporating provisions mutatis mutandis. Then we go to chapters 3 and 4 of Title 1 of this section on SPS and TBT. SPS, it's been one of the trickiest areas in EU-UK relations since 2016. And the need to comply with new SPS requirements has been a significant barrier to trade for producers since the TCA came into effect at the end of 2020, with the UK being a third country. It's also an unequal administrative cost, as EU exporters, they don't face checks in the other direction. The UK has postponed the implementation of checks. Last month, they announced a 5th postponement, rolling back checks on EU goods entering the UK. So what are the options for an SPS agreement? Is it, on the table? As a basic principle, I discussed that the more the UK diverges from EU standards, the more limited the options will be. So during the TCA negotiations, you may recall there was discussion of the UK wanting equivalence, the EU wanting dynamic alignment. But discussions of both of these options, they're off the table if the UK diverges significantly in this area from the EU. And a point I emphasize is that the UK, it has to balance pursuing new opportunities with minimizing disruption to exports to the EU. The UK has concluded new trade agreements with Australia, New Zealand, CPTPP. And the question is the extent to which they will oblige the UK to diverge from EU SPS standards. Divergence, it has been described as being of academic interest, but I don't think that's the case. If you consider that Keir Starmer has said he wants a major rewrite of the TCA, and a veterinary agreement has been specifically mentioned, such divergence, it could tie his hands, lock UK products out of the EU market. So it's a very significant question. Under the CPTPP, this Trans-Pacific Partnership, regulations on the import of beef and pork should be based on science and risk analysis. No reference to the precautionary principle, as is the standard in the EU. The UK government has promised it won't lower standards in areas like food, animal safety, but it has also promised that it will fully comply with its TPP obligations. So Canadian meat exporters will be eagerly watching what happens next if they aren't given access to the UK market, and the EU will also be watching what happens in the UK here. So in my chapter, I point to the fact that in the UK's impact assessment on joining CPTPP, it's not even mentioned. There's no sense of the ban on hormone-treated beef being addressed, and whether joining will entail divergence from EU SPS standards. And the same is true for the impact assessments for the Australia and New Zealand trade agreements. But regardless of this, just park that for a minute, EU-UK veterinary agreement, it may still be a possibility, evidenced by the fact that New Zealand has such an agreement and it is a member of CPTPP. The Swiss also have a veterinary agreement, which is far more comprehensive than what New Zealand has, where border checks are basically completely abolished. But both agreements should be models for the UK to look at. Starmer wants a rewrite of the TCA, but any movement away from the EU regime, it will have a knock-on effect in the area where they're looking for, alignment with the EU. So the House of Lords called for an SPS agreement as an urgent priority. And I say in the chapter that the UK should aim for a bespoke veterinary agreement with at least the level of ambition of the New Zealand agreement, and it should seek to approximate to the provisions of the Swiss agreement in certain areas where possible. If the UK government seriously wishes to pursue such an agreement, it could commit to aligning with EU standards in the areas where it wants equivalence as an initial step. So the UK, it will continuously face this choice between whether to diverge or whether to seek increased cooperation with the EU in this area. And a point I would make is that the UK should try to avoid introducing rules that cannot easily be reversed in the SPS area, and that it needs to be clear if it is doing so. It's one thing if changes are introduced as part of a comprehensive trade strategy, But if they're introduced without public deliberation, it risks stumbling into suboptimal trading arrangements. So I think I'm approaching my time. So just one final point on technical barriers to trade is that it's a really welcome decision last month that the UK scrapped its plans to introduce an alternative to the CE marking system. So it's really a promising sign of cooperation, but I'll skip to my conclusion. So recent compromises point to a more pragmatic and cooperation-based approach to EU-UK relations. The conclusion of the Windsor Framework and recognising CE marking in the UK, they're signs of cooperation, listening to the business community, and we really need to build on this and reducing the friction of Brexit. So next questions, they relate to things like SPS agreements, whether the UK should join the PEM Convention, and whether a deal can be reached on electric vehicles this year. I just finished by saying that the recent momentum we've seen, it should be sustained, particularly where there's mutual and global benefits, such as in the area of EVs. And I'll leave it there.
Thank you very much, Dr. Moran, for, again, another very detailed and very clear presentation of your chapter. Without further ado, we're going to move to our fourth speaker of the session, which is Dr. Mariella de Amstelden, whose research explores the legal implications of emerging biotechnologies, in particular animal cell cultivation, and their implications for international economic law and global governance. She has a monograph called Global Food Governance, Implications of Food Safety and Quality Standards in International Trade Law, which was published in 2015. And she has experience in private practice and the judiciary, and has published a number of peer-reviewed articles about the law of emerging biotechnologies, food and public health regulation at the intersection with international economic law and global governance. The floor is yours.
Thank you very much for that kind introduction. I am going to try to share my slides with you.
I don't know if everyone else has the same problem. We can't hear you very well.
Let me see if it solves it.
Try speaking again to us. No. So when you unplugged your earphones, we can't hear you at all. But when you put them in, we can hear you. I can hear you a little bit, but not very well.
Should be better now.
Ah, very good. That's much better. Thank you.
Well, thank you very much for that kind introduction. And I might disappoint you in that I am here today to talk about intellectual property and capital movements, as opposed to food safety and biotechnology, which is also one of my areas of expertise, I would say. So thank you again to Federico for inviting me to contribute to this conference and also to this volume. It's been fascinating to get to grasp to what the TCA is up to. And so you will see from my slides, I have a couple of slides. They're primarily pictures. So for those of you that are more inclined to read text, I apologize in advance and thank you for bearing. What I will talk about in the roughly 40 minutes that I have is primarily, as I mentioned, capital movements and intellectual property rights. And what I'm going to tell you is mostly based on what I've wrote for the upcoming book. So first, I will focus on some of the key elements of capital movements as we can see them on the TCA. And in order to do that, what I did is trying to map the legal architecture of those bases, and in particular, trying to focus on the free flow of capital. So what it is understood under capital movements in Articles 213 to 217, the TCA. So as you see, it's only five provisions. And then I will focus on intellectual property protection. First, I will talk a little bit broadly about intellectual property protection under TCA, and then I will be brief, but I want to touch on substantive IP protection, especially as it relates to trademarks, copyright, and patents. So, as we've heard before, there is a bit of a I guess we're all a little bit disappointed that there isn't much about investment protection. But perhaps we can see something on that when we talk about capital movements. So these 5 key provisions, in my view, provide an underlying rationality for protection, which is basically the free movement of capital and payments. These payments and transfers are related to transactions on current accounts, and those are allowed on the proviso that they are freely convertible currency, as it complies with the article of agreement on the International Monetary Fund. So you will see that this is basically dating back to the Bretton Woods Agreement. So we're going back in time, trying to find some sort of common ground when it comes to what can the EU and the UK agree on as it comes to the movement. Reference to international provisions predating the constitution of the EU might lead to the preliminary conclusion that at first sight, it is a rather shallow integration, as I mentioned, at least with reference to this particular aspect. At closer examination, however, I think it becomes clear that an additional key objective of these 5 agreed provisions is the liberalization of investments, and that is clearly stated in those provisions. And I guess one could say, as we've heard also from my fellow panelists, that in the absence of a dedicated investment chapter, we have at least some sort of meeting of minds when it comes to capital movement. So overall, the provisions on capital movements are guided by non-discrimination and regulatory autonomy imperatives. And these are 2 key principles that, as we've heard before, are underlying the rules of the World Trade Organization. And so in a way, and I will come back to this while I'm concluding, the TCA rejects a EU law minus approach and instead opts for a clear favoring of what we might call a WTO plus one, providing for a loose but in principle sufficient, at least in my view, set of rules to ensure that commitments related to trades and services are met. Now, more specifically, the rights and obligations derived from 2 of these TCA provisions, 213 and 215, are not intended to encumber on parties' regulatory autonomy as it relates to a number of key features in capital movement. And this is something that we've heard throughout the presentations, the right to regulate and the importance of regulatory autonomy. And so you see here that what I focused on is in elucidating to what extent regulatory autonomy is permeating articles that are designed to provide a legal basis for capital movements. There are also provisions providing for a legal basis for temporary safeguard measures, and I thought that was particularly interesting, according to which the EU retains the ability to adopt temporary measures for no longer than 6 months to the extent that they are strictly necessary. I think for those of us that are acquainted with WTO law, this is very familiar language, clearly showing that the legal threshold is much more stringent for exceptional circumstances. And I think that has a particular importance when we think about the financial crisis a couple of years ago. So now moving on to intellectual property protection, and I'm happy to take questions on capital movements if there are any afterwards. I will focus on 3 key elements, which I thought were very clearly spelled out under the provisions of the DCA. And those are the minimum standard of protection, exhaustion, and national treatment. So first, the TCA aims at facilitating innovation and creativity in goods and services while reducing the trade distortions and contributing to a sustainable and inclusive economy. I emphasize the sustainable and inclusive element of the provision. It also aims at establishing between the parties a minimum standard of protection to enforce intellectual property rights. So this mix of objectives is not unusual in international intellectual property agreements, and yet some of these elements display, in my view, a rather forward-looking character. While the promotion of innovation and creativity through the granting of exclusive rights has been at the core of IP protection since its inception, and if we go back to the examples of the Paris Convention for the Protection of Intellectual Property of the 1888, the Berne Convention, we see that the reduction of commercial barriers was not at the core of those international intellectual property agreements. And so one could argue that perhaps the inclusion of such an element is the result of TRIPS, of the WTO Agreement on Trade-Related Aspects of Intellectual Property Rights, the TRIPS. So the TCA makes explicit reference to the link between IP protection and a sustainable and inclusive economy, which is what I emphasized a couple of sentences earlier. This is, in my view, a provision not often seen in intellectual property chapters. As a result, the TCA can be seen in a way, perhaps as a pioneer in its attentiveness to the Sustainable Development Goals and the role of intellectual property and what is the impact that it can have in creating and maintaining an inclusive economy. So in a way, from an intellectual property law perspective, these are exciting things to see in an international agreement. So the scope related to the exhaustion, now moving on to exhaustion, the provisions related to exhaustion of IP rights are established under 223 of the TCA. And it's particularly significant because it maintains the right of the parties to determine whether and under what conditions exhaustion of intellectual property rights apply. Now, exhaustion is a quite contentious concept among intellectual property scholars. For those of you not acquainted with it, it's a distinctive feature of intellectual property law, according to which an IP owner is prevented from exercising some of their exclusive rights in certain conditions. And so it plays a predominant role in selective IP rights, sometimes contentiously, like patents and copyright. So it is quite significant that that provision is included. Now, in terms of national treatment, and this takes us back again to WTO language, this can be seen as another pillar of IP protection under the TCA, just as we've seen that it is an underlying principle in other articles of the TCA. So according to its Article 224, which makes explicit reference to it, parties are obliged to mutually accord no less favorable treatment than that accorded to their own national. Under the proviso that of exceptions already provided for in other international intellectual property conventions, like the Paris Convention, the Berne Convention, and others that I mentioned previously. So this is a sort of a broad scope of how the intellectual property protection chapter under the TCA diverges in a way from what we've seen so far in international intellectual property agreements. Now, if we go to the substantive elements of intellectual property protection, let me talk you through briefly through copyrights and trademarks and patents. So substantive copyright protection is largely implementing existing agreements prior to Brexit. And in a way, those are minimum standards of protections that have been set and are continue to be respected. And there are selected cases of mutual recognition, which is not something that we've seen that much along the TCA. So rules relates to cross-border copyright arrangements, such as clearance for satellite broadcast, reciprocal protection for sui generis database rights, and more importantly, orphan works exceptions are not part of the DCA. So here we see how the negotiators actually sort of try to avoid the hot potato in a way. So they didn't reach agreement on that or explicitly decided not to include that. And there are other ways in which these elements of copyright law have been dealt with, notably through guidelines, which are obviously not as mandatory as other types of course of law. One particular element of copyright protection under the TCA that I thought was notable was that it provides for the protection of technological measures used to prevent copyright infringement. Now, please accept my apologies because IP law is quite technical in a way, so I'm rushing through a lot of technical knowledge. But so you might see that for copyright infringement, artists, pictures, videos, you've seen probably in the news lately how they became increasingly important in the age of AI, and how do we protect that from an intellectual property perspective. And so the fact that there is a provision for the way to avoid copyright infringements in the TCA is also notable, and it's also in a way forward-looking. So if you allow me to take you through trademarks, as with copyright protection, trademarks, the substantive provisions on trademarks reflect those of the EU Trademarks Directive. So it's largely the same as what we had prior to Brexit. We have trademark capability under Article 237 of the DCA that says that trademarks can be constituted by any sign that displays distinctiveness and that can be graphically represented. So that is largely reflective of what we had prior to Brexit, and in a way that is uncontroversial. However, there are a number of elements when we talk about trademark exceptions that are notably diverging from what we've seen before in the EU regime, and it alienates better with what we know from the TRIPS agreement. And so largely it's mirroring what Article 17 of the TRIPS agreement says about trademark exceptions, with one notable difference. There is an inclusion of geographical indications as an example of fair use of descriptive terms. Now, this is also hugely controversial. I will come back to that in a minute or two. What I am arguing in the chapter is that while the reconceptualization of geographical indications as fair use is far from uncontroversial, this particular provision under the TCA might shed some light on the matter, because it establishes that rights conferred to registered trademark owners do not include the ability to prevent third parties from using an earlier right applicable to a specific locality in the course of trade. So as you know, geographical indications have a strong geographical component. And so the fact that under the TCA, geographical indications are not qualified as a collective trademark, but are qualified under fair use is very significant. Now, I'm going to move on briefly to patents before I conclude. It is noteworthy that the section dedicated to patent protection under the TCA starts with reference to the nexus between patents and public health. The emphasis on medicinal and plant protection products under patents, particularly the explicit reference to the Doha Declaration, which is the Declaration on the TRIPS Agreement on Public Health, and the needs to ensure consistency in the interpretation of those patents rights is significant. We've seen a lot of disputes coming out of that particular element of intellectual property law and how that interacts with public health. The fact that the substantive patent law provisions under the TCA they start with explicit reference to the nexus between patent protection and public health is in many ways significant. Perhaps this inclusion can be attributed to the mere passage of time, precisely because of the disputes that we've seen in the past. But its rationale could also be found, I say, excuse me, in the desire of the parties to maintain recourse to so-called TRIPS flexibility. And there is a large body of scholarship dealing with TRIPS flexibility. And that, in a way, fits into what we've said before about the right to regulate and regulatory autonomy. Or, in other words, policy space left to WTO members to adopt measures as deemed necessary to protect its population. And we've seen a lot of that taking space and form within different provisions and different chapters and different parts of the TCA. Lastly, three key elements that I thought were particularly noteworthy is in terms of intellectual property protection and the TCA is cooperation, voluntary stakeholder initiatives, and as I mentioned previously, geographical indications. What I would like to say briefly about cooperation is that, as we've seen, and I made my notes about what my fellow panelists have said about cooperation, what I've argued or what I've explained in this chapter is that in times where international cooperation is no longer taken for granted, the TCA makes explicit provision under its Article 273 for cooperation, clearly for cooperation as opposed to equivalence or harmonization or mutual recognition in support of the implementation of IP rights and obligations. When it comes to voluntary stakeholder initiatives to reduce IP rights infringements, the fact that there is a specific legal basis is significant. While a continuation of already established practice, the use of voluntary stakeholder initiatives in other elements, there is evidence supporting that this sort of evidence are particularly effective when it comes to IP, when it comes to the prevention of IP infringements. As such, This particular provision under the TCA recognizes the importance of alternative, supplementary, and forward-looking ways to prevent IP rights infringements that are commensurate with technological advances. And that in a way also fits into the provision that we've seen earlier in terms of copyright, where there is explicit mention of the importance of technology when it comes to preventing copyright infringement. Now, lastly, when it comes to GIs, as I mentioned previously, they are a seemingly contentious matter. The TCA remains silent on substantive provisions for the protection of GIs as collective marks, which is telling of the sensitivity of the matter as it relates to international trade. And we've seen a number of contentious debates about whether or not to include geographical indications under free trade agreements, including with Australia and New Zealand on the side of the UK. So I think I gave you most of my main thoughts on the chapter that I brought. So I would like to leave you with a few concluding thoughts, which is basically a summary of what I intended to convey in these past few minutes, which is, depending on how you look at it, the TCA could be a WTO plus free trade agreement as opposed to an EU minus. The voluntary stakeholder initiatives seem to indicate an element of an emerging, seem to indicate that there is some signs of emerging novel forms of global governance, or perhaps it's just an evidence of lack of agreement, and I am just being optimistic when it comes to developing new theory. And then lastly, the GIs, and this is something that I talk in more detail in the chapter, might well serve as a stress test for the Windsor framework. So thank you for your attention. I'm going to
Thank you very much also for that, and for the very interesting pictures in your slides. The graphic designers have been busy, I see. So we will now open the floor to questions, comments, reactions to all four of our speakers' contributions. So if you'd like to make a contribution, maybe you could just raise your hand and we'll see where we go with that. Yes, please, Niall, you're first with your hand up there. Thank you.
Thanks a lot, Sharon. Yeah, so just a quick question for Mariella on the geographical indications. So I worked in negotiations on this as part of the TTIP negotiations with the US, and it was a nightmare. It was a non-starter basically for the US for specific reasons. They have their own system that's very different to the EU. Unlike the UK. But I just wanted to ask, do you have the impression that the UK sought to get much leverage in this area, or was it willing to give the EU what it wanted fairly easily here? Because ultimately, I think it's an area of mutual interest, but just seeing how closely the EU values it, did the UK play hardball in this area, or what your impression is of that area?
May I reply? Yeah. Thank you for your question. Yeah, may I just say that it's an absolute pleasure, of course, to be presenting with all my fellow panelists, but particularly to be presenting with Nia, with whom I'm co-editing a book. Sorry for the shameless promotion here, and it's just about to be out in a month's time. So thank you for that question. What I might say in response to that is merely speculative, but my sense is that the UK wants to leverage its new position, as opposed to having given in to something that the EU did not want to agree to. And the reason being, if you look at the Australia and New Zealand free trade agreements with the UK, they are also very vocal from the UK perspective. They are very vocal about everything that it's going to be done in terms of geographical indications and how that's going to benefit trade. So I think in a lot of ways that is being used very much so as leverage. And so there is my sense is that there is no willingness is the wrong word, but there is no desire to keep the EU happy when it comes to this. And there is a sense of, okay, let's explore what the Commonwealth has to offer. Let's see what the US is going to say about this. Let's see how Canada is going to react. So I think there's a real sense of leverage when it comes to GIs. And it's surprising how how much power something so obscure in IP law can become. Because as you say, they can become quite a nightmare when it comes to technically analyzing what they are or what they are not.
Thank you for that. And I see we also have a question from Pinar, if you'd like to ask your question there.
Yeah, thank you very much. I just wanted to ask Niall, a very interesting presentation also, from the angle that we all are looking at what's going on in the sphere of EVs. And I was wondering, I mean, we all are aware of the IRA, Inflation Reduction Act, and how the United States is proposing the local content requirement, which is seriously looked into by the World Trade Organization, departments as well. So when you look at the TCA and the negotiations between the parties, and we know that everybody is trying to be self-sufficient, including the European Union, do you think that there's a potential for the United Kingdom and the European Union to have some, better approach to local content requirement for electronic vehicles? Is there anything special about that in the agreement itself? If there is not, can you see a possible opening between the parties of introducing a local content requirement in a manner that will be compatible with the WTO rules? Thank you.
Thanks very much for the question, Professor Arter. Just to clarify on the last one, yeah, I was saying that the negotiations themselves were a nightmare. Just because, yeah, there was just a pure conflict here between the US and the EU. But geographic indications themselves, I love them. But to get on to Professor Ardan's question on electric vehicles, yeah, of course, everything that's done here, you are looking across the Atlantic and the Inflation Reduction Act, and I think that there has to be very clear rules on what constitutes a green subsidy, and this is a concept that it's going to have to be developed much further. As you say, the EU and the UK, we want to be self-sufficient in this area. What are the better ways to do this? Just to come back to my point on integrated supply chains, I think of course it makes a lot of sense, and you see airplanes being manufactured in Europe, and the supply chain spans the EU and the UK, and I think that we need to facilitate this in the area of electric vehicles as well. And as I said, kind of my conclusion that area was joining the PEM Convention to provide for accumulation across the whole of Europe. To me, it seems like an easy win. It's hard to see the benefits for the UK of staying outside of that. And if they do join, I think it is the best way for them to embed themselves. And when these decisions are being made about constructing these supply chains, they're not going to be as long as they are for normal automobiles or for planes. But still, it gives the UK the best chance to be part of the continent-wide supply chain if there's common rules of origin across Europe, the EU, and the UK in this area. So the opening I see is, firstly, I think that extending the impending rules of origin requirements coming in December, that needs to be done. I try to speak strongly in favor of that. I think it's an imperative for many reasons. So let's hope there's some action on that. That'll be my first point. I see. Oh, there's another question.
Thank you.
Yes, we have another question there from, I'm not sure what your first name is, but I beg your pardon. So, Federico, do you know the...
Billy, yeah, I think we are...
It's Billy. It's Billy. It's very simple. Sorry, it's just this. Hi, everyone. A lovely set of presentations. So I have two questions, and actually they're tied together. It's a question for Pinar and for Niall. You both listed a number of areas where the TCA could be reformed, and there are two particular set of reforms which struck with me, because these were areas where I think the EU was the one who was resistant to go further. So, Pinar, you mentioned investment protection. And I agree with you that the TCA's text is actually quite conservative when it comes to investment protection. but it's pretty much in line with the recent EU trade agreements. So if you look at, for example, the text of New Zealand trade agreement, it's pretty much in line with those with the text that's been put forward by the EU in those agreements. If you also look at the negotiating directives for the EU-Australia trade agreement, I think they've excluded investment protection, ISDS, and I think it's mostly an issue of competence. Really, they want to negotiate EU-only agreements, and they want to have the member states involved in the process. So it seems here that UK is not the problem, because the UK doesn't really have a coherent strategy when it comes to trade policy and investment in general. It's quite happy to go with the flow and be flexible and negotiate whatever the third party FTA partner wants to. So the problem seems to be from the EU side, and I wonder whether you have any thoughts in terms of whether that approach adopted by the EU, that stance, might change. And if so, why would they? So is the pain that goes with negotiating investment protection and ISDS, or the political pushback, is that worth it? What do you gain? The pros and cons of including a more comprehensive ambition investment protection chapter in the TCA. Is it really worth all the hassle? For now, you mentioned rules of origin, and that tied in really well with what we were talking in the previous panel. And in particular, you mentioned the PEM Convention. And again, this is an area where I think the UK was quite keen on, for example, including diagonal accumulation in the TCA. And it was the EU that said, hold on, we're not that keen on it. And there was never a formal explanation for it. But I think largely it was about making sure that it attracted more investment, right? And that if you had a fully integrated supply chains, then UK might have an advantage in terms of securing investment. So I'm wondering if what has changed since then that the EU would look at this again and say, actually, diagonal accumulation, for example, would be something that would be willing to include in the TCA. Because of course, even with Northern Ireland, that's huge repercussions and potential benefits in terms of facilitating GB Northern Ireland trade. And I don't have any questions for Elaine or Marielle, but the great presentations, and I learned a lot. So thanks for that.
Thank you for those questions. So I think that was directed both at Pinar and Niall. So which of you would like to respond first?
Yeah, I think I can start. Thank you very much. Really, I mean, these are very meaningful questions to which I don't have the perfect answer probably, but my initial reaction when I was reading the chapters, and I didn't only read the chapters, but I went through lots of different documents, including some major law firms who are working on investment arbitration, making their commentaries about the TCA and the chapter on investment protection. It seems everybody's upset, including myself. Especially compared to certain agreements. Of course, one cannot really, compare China with the United Kingdom, considering China is probably a horrible place for, when you are an investor and you know that your intellectual property is stolen or some other things are popping up. When you compare CAI, the Comprehensive Agreement on Investment by the European Union, and some other, major efforts, the TCA is nothing. This can be probably linked to the idea that probably the European investors will feel very comfortable in the United Kingdom because, after all, this is a rule of law state, and probably all of the institutions in the United Kingdom, whenever they are hosting the investors are trying to be in line with the laws and transparency and due diligence, etc. But nonetheless, I mean, I think, one could be a little bit ambitious considering how investment is important. But the answer I came up with is probably due to the fact that the European Union is so keen on this multilateral investment court, even if it will never be able to convince the United States to be on board. And they still couldn't convince the other negotiators within the, United Nations UNCTAD, working group 3, Colin Brown and, all these people. So, but I am thinking that probably in the future, they will have to bring certain changes to the investment chapter, but not anytime soon. So, within the, 5 years review time, probably this is not going to come. But if, European Union gets any meaningful result from these, make the multilateral investment court negotiations, that could be reflected, some, principles could be reflected there. In particular, I would see probably much more policy space argument, and also, chilling mechanism. There is no, relevance to that in the, existing. So, we have to wait and see, but thank you very much for the question.
Thank you very much. And Niall, do you want to respond?
Yeah, thanks very much for the question, Billy, and congrats. I saw you were recently made professor at QUB. So just on the question of the EU resisting going further, I wouldn't necessarily agree with that framing. To me, it's a balance of obligations and freedoms that's Brexit. And in some areas like SPS, for instance, a clear example where the UK doesn't necessarily want to accept the obligations necessary to go further. So on rules of origin specifically, you asked, what has changed here, and nothing has changed basically. But the initial position was that the UK wanted diagonal accumulation without joining the PEM Convention, and that the EU stance remains the same. It's only giving, only allowing for that type of accumulation along with joining PEM membership. The EU hasn't offered this to anyone outside of that on a bilateral basis. The UK, it's a third country, and while it did want that to go further, that's the EU's kind of positioning on that type of accumulation. And I suppose it ties in with just being able to monitor what's coming in and out of the single market, not wanting to loosen the rules too much so that goods can more easily enter the single market from UK trade agreements with far off destinations. Thanks very much for the question.
Thank you, Niall. So we will close shortly. So I was wondering if anybody else would like to ask a question before we do that, or make any comments. It doesn't look like it. So I think we might decide we have come to the end of the panel. Again, I want to thank all of our 4 speakers for interesting presentations and for staying to time, and obviously everyone else for participating and listening. I know you have a whole other session or group of sessions tomorrow. I don't know, Federico, if you want to make any announcements about that, or...
Yes, thank you, Sharon. And let me first of all thank you for chairing this panel. I must say, from a D&I perspective, it was wonderful to have an almost all-female panel plus Niall. So I think we are very proud. We are very proud that we put together a good female participation for this event. But indeed, we are continuing tomorrow morning at 9 a.m. Irish time for the last 2 panels. So we have 4 more speakers before the conclusion. I just would like to remind everyone that you need to register for the second day to get the new Zoom link for tomorrow. And therefore, we all look forward to seeing you tomorrow morning online at the Brexit Institute of DCU again. Thanks a lot.
Bye-bye, everyone. Thank you. Good evening.